is Professor Moni Wekesa. And we'll take 1 minute for the pictures and then we'll continue with the interviews. I think that is enough. Once again, welcome Professor Wekesa to this interview. We want to thank you for availing yourself.
Thank you, Honorable Chair.
And we'll start by introductions. My name is Professor Olive Mugenda, Commissioner representing the public, and I'm chairing these interviews. And to my right.
Good morning, Professor.
Good morning, Honorable.
Philomena Mbetemuilo. I'm the representative of the Supreme Court to the Judicial Service Commission. I'm also the Deputy Chief Justice of the Republic of Kenya.
Thank you very much, Honorable DCJ.
Good morning, Professor. My name is Pat Kishoi, representing Public Service.
Thank you, Honorable Kishoi.
Good morning, Professor. My name is David Majanja, Judge of the High Court, representing the Kenya Magistrate and Judges Association.
Thank you, Honorable Majanja.
Good morning, Professor. My name is Oluwande Evelyn. I am a Chief Magistrate. I represent KMG.
Thank you, Commissioner Honorable Oluwande.
Good morning, Prof. My name is Machari Njero. I represent the Law Society of Kenya. Welcome.
Thank you, Honorable Njero.
Good morning, Professor. My name is Felix Koske. I represent the public.
Thank you, Honorable Koske.
Good morning, Professor. My name is Mohammed Warsame, Judge of Appeal. Welcome.
Thank you, Honorable Warsame.
Very good morning, Professor. Kehara Kariuki, the Attorney General, and on this panel by virtue of that office.
Thank you, Honorable AG.
Professor, we also have Honorable Anne Amadi, who is the Chief Registrar of the Judiciary and the Secretary to JSC.
Good morning, Professor.
Good morning, Honorable Amadi.
And we also have our Registrar JSC, Honorable Frida Mukaya.
Thank you, Honorable Mukam.
Professor, as we've been telling other candidates, if you have any problem with any question or you need clarification, you are free to ask the Commissioner. We are all going to ask you questions, the 9 commissioners, and after 2 hours we are going to have a short break, so you can also rest a bit. So and now we will start the interviews. Professor, and I will be the one to ask the first question. First of all, let me commend you for a very impressive CV. It's very detailed, and you have done a lot of work, Prof, and thank you for that hard work. I also note that in the 80s and 90s, you are in education, and I must confess that we are together teaching at Kenyatta University. In the 80s and 90s, particularly in sports education, and then in the 20s, you moved to law. Could you please tell the Commission that journey of transiting from education to law?
Thank you, Honorable Chair. My life started in a village called Namirama in Navaholo sub-county of Kakamega County. Went to Namirama Primary School, Musire High School, nicknamed Box 14, Chavakali High School, then University of Nairobi, where I obtained a first-class honors Bachelor of Education degree 1981, master's in sports medicine and rehabilitation, and PhD in the same from Cologne, 1986-89. Then came back to do service to the country. Honorable Chair, in the course of doing service to the country, I traveled with the national junior soccer team to Helsinki in 1992. One of the boys punched somebody there and he was arrested. Now, the coach and team manager said, Daktari, wewe ndio unaweza kuongea na hao watu. Sasa enda utusaidie kutoa mtu yetu. Honorable Chair, I felt totally handicapped. I thought I had attained. I thought I had read it all. Of course, I then went to the police. We had a long talk. They released our boy, and that ended it. But then at that moment, I started asking myself, what is this law, and what authorities would Finland or authorities in Finland have over Kenyans? That's a question that started plaguing my mind. Come the following year, Honorable Chair, we traveled to Cairo with the with the senior team now. Normally, clearances are very easy at customs. The national team collect passports, they are stamped en masse. We went through. Getting to Cairo, we were received by the football officials just before the customs, collected the passports, stamped, we got in. Coming back, each person was required to have their own passport. Then it turned out that the team manager had taken a passport that belonged to a different player and attached it to a player who didn't have a passport. So he was arrested at customs. Then once again, the coach and team manager say, Daktari, wewe ndio naelewa hii maneno, tusaidie. I went to the customs officials, we had a chat, a long chat, but of course now at that point, my point was, here is the plane waiting. This person is going back to his home country. Why would you want him to sit here and live on your expenses? Kindly just allow us to go. We shall sort out this thing when we get home. He was eventually released. From then on, Honorable Chair, the seats of studying law were sold. So then I went to law school, graduated with a bachelor's degree in 2002, master's. When I went to do the bachelor's, my idea was to specialize in international law because of what I had experienced out there. But getting in, I found some more interesting areas like law, science, technology, and sports law. So I eventually diverted in that at the master's and PhD. Honorable Chair, have I answered the question?
Yes, I think you have, Professor. And I noticed that you use double doctor, so you call yourself Professor Dr. Moni Wekesa. Is that more of a German tradition, or is it your preference?
Honorable Chair, we have different academic cultures. Those people trained in the US, like the Honorable Chair, just write their names, Olive Mugenda, PhD. In the UK, just write Doctor, so and it's done. In Central Europe, the culture is totally different, right? Professor, doctor. If you have 2 doctorates, professor, doctor. If you have 3, the same thing.
Okay, so it is a culture.
So it is a culture I picked up from one of my alma mater.
Okay.
And Honorable Chair, it is doing wonders here also because very many people have been encouraged. One came to see me in 2019. He said I had encouraged him. He had a PhD in entrepreneurship and a PhD in law.
Wow. Okay. Thank you very much for that. Professor, again, looking at your CV, I noted that you have held many leadership positions, chairman of department, dean, and different universities. So what leadership qualities do you possess, Professor, to make you a great CJ if we select you?
Honorable Chair, I am a transformative leader. With that, I mean, I'm a good communicator. I'm good at problem solving. Bring in a problem, I'll see how to sort it out. I listen to others. I engage with others. I pay attention to other people's views. I build teams. I bring out the best in others. I encourage others to offer their best. I'm consultative, collegial, and all that makes a good leader tick.
So what is your understanding of a transformative leader? Because, Professor, I think you can communicate well, you can listen, you can build teams, but you are still not able to transform. So what is a transformative leader?
Honorable Chair, a transformative leader is one who is able to look at a vision, get the team to buy into the vision, set specific objectives, motivate people to work towards achievement of those objectives, and where one may be lacking behind for whatever reason, the person is encouraged to come along. It's a way, through this kind of leadership, one is able to carry everyone on board. One is able to encourage everyone to do their best. All through my leadership positions, I've always told people I've worked with that please tell me your strength. We cannot sit anywhere screaming about weaknesses. Tell me your strength. Let us build on your strength and see how together we can move this team forward, this organization forward, this school forward, this department forward.
So, Prof, could you tell us practical examples or situations where you have transformed an institution or transformed a department or done something transformative, very practical example in the areas where you have been working?
Thank you very much, Honorable Chair. I started the School of Law at Mount Kenya, hiring staff, recruiting students, ensuring that the staff deliver so that the customer is happy, getting that together so that we all move and speak from the same language. Honorable Chair, while at Mount Kenya School of Law, I decided we needed to get our students to start behaving like lawyers. So I had a chat with the student leadership, had a chat with them, and we introduced the wearing of suits. At Mount Kenya University School of Law, Monday, Tuesday, every student is in a suit. They like it very much, they look very responsible, they appreciate it, and that has taken root. And it's up and going. At Daystar University School of Law, now with a little hindsight, we made it Monday to Friday. So all law students look very smart. They look the part. They have chosen to be lawyers. They start that from day one, looking, behaving, thinking like lawyers. But allow me also to mention, Honorable Chair, that around 2012, we had a problem as a country in the area of sports. Our athletes were winning, our teams were playing and winning, but there was a dark cloud hanging over our athletes because of an animal called doping. Doping is the use of prohibited substances or a form of cheating in sports so that one wins, not because they are putting their own effort, but because they have taken some drugs. At about that time, Honorable Chair, over 30 Kenyans had tested positive and their names were being flagged on websites globally. So then we started getting bad publicity in the international press. The then Minister, Honorable Tuoma, tried to issue a press statement. He didn't help. Pressure started coming in, especially from the World Anti-Doping Agency, and the thinking in the international circles was, if these Kenyans are winning through cheating, we just lock them out, let them compete amongst themselves. But then for a sports person, competition only makes sense if it's international, and it's from the international competitions that they're able to make money. So then there was that threat. Coming after elections 2012, a new cabinet secretary comes in and he says, let's get to the bottom of this. So I was appointed to chair a task force on to investigate matters of anti-doping in 2013. At the time of appointment, I was doing something at the Université Libre de Kigali. So I just got news of that while there, came back. I found a wonderful team of 12 people I had never worked with before. 5 lawyers, 2 medical doctors, 1 from Nakuru, another one from Mombasa, sports officials, and from the AG's office, from the ODPP, from the sports ministry, from everywhere. 12 of us. After the first 2 meetings, Honorable Chair, we gelled. We worked on focusing on the objectives. We worked on the objectives, produced a report. The report was received by the government. It was very well received by the international community. The government acted on it, and as we sit here, Honorable Chair, we have an anti-doping law in place. We have an anti-doping agency in place. The international community is no longer doubting our sports persons.
Okay, thank you for those examples, Professor. I'm just thinking about the rule for students to wear suits Monday to Friday. And I'm just wondering whether, when you think of a university student, you're thinking of blue jeans and T-shirts. I mean, that's the life of a student. Now, if they are wearing suits, and nothing wrong with that, but have you considered those who may not be able to afford the suit Monday to Friday? Have you taken care of them?
Oh, yes. Honorable Chair, that question came up in our discussions, especially at Mount Kenya. And it was in that light that the students said, okay, sir, we think the idea is very good, but then some of us may not be able to afford 5 suits at a go, meaning if I have 1 suit and I'm wearing it 5 times a week, after 1 month, it will no longer look like a good suit. So kindly allow us to implement this in a progressive manner. So we said, okay, how do we do it? Then they suggested, we were discussing like in this semester to start the following semester. They suggested, well, for the following semester, let us make it 1 day in a week. So we said, okay, Monday. The semester thereafter, we make it Monday and Tuesday. So we did it progressively to accommodate those who would have challenges. This, the Honorable Chair, it is in the admission letter. It's part of the requirements.
But you must come with
yes.
suits. Okay. My last question to you, Professor. I'm sure you have thought through the role of a Chief Justice. So if we nominated you to be the Chief Justice, please tell the Commission what you do the first 3 months, immediately, short term, maybe 1 year, and then long term.
Honorable Chair, the first thing I will do after I come in May next month is to work on mending relationships between the judiciary and the other arms of government. For me, that would be the first agenda on my list. The second agenda, Honorable Chair, is to build allies, to take the judiciary to the people. So far, the judiciary has done a lot. There are very wonderful reports about this and that and percentages, but somebody in the village in Magarin doesn't know about that. Border riders gathered somewhere in Kakamega don't know about that. So my next agenda would be to take the judiciary to the people. What am I saying in practical terms, Honorable Commissioners? We have professional bodies here. We have the Kenya Medical Association. We have the HR professionals. We have this and that. I want the judiciary to be present at each of their annual meetings. We get a slot and just tell them about the judiciary, what we do. all the professional bodies, and all of them hold annual meetings. The second group, Honorable Chair, the Kenya Association of Manufacturers. We read about them there, we meet them in court, but they are also human beings, they are people. I would want us to have a session with them, a structured meeting with them, just to tell them about the judiciary, what the judiciary does, and all that, so that they also can, buy into the judiciary, accept it as their own. Honorable Chair, we have trade unions in this country. We hear about them when there are disputes in court, but I would want us to have occasion when they are having their normal meetings. We send there, say, Commissioner Koske, to go and talk to them about what the judiciary has done, what the judiciary is doing. Honorable Chair, we have law schools. At the moment, our relationship with law schools is not formulated at all. With respect to law schools, Honorable Chair, I'll want about three forms of engagements. Number one, we get all employees of the judiciary who have postgraduate degrees to offer to teach at least one course at the university. So if someone is CPA, Dr. So-and-so in finance, let the person identify the university where the person can teach at least one course in finance. I want this magistrate in Homa Bay who has a master's degree to volunteer at least 3 hours to go and teach. Let us be able to interact with other members of the university system so that they are also able to feel the judiciary. Honorable Chair, at the moment, law schools have better courtrooms than the judiciary. And this is because the moot courtrooms are modeled along the lines of the courts at The Hague. Beautiful, networked, and so on. Added to that, courtesy of the Council of Legal Education, each law school has some kind of area of focus or specialization. I would want the judiciary to enter into some kind of structured engagement with each of these law schools so that using their ports of strength, they are able to develop moot court sessions which would then eventually be televised. We have very many TV stations. So we can have, for example, Citizen running a program on family law offered by Catholic University. We have NTV running a program on environmental law from the University of Nairobi. We have KTN running a program on communications law from Daystar University, and so on. But then again, weekly programs. When we were growing up, we used to hear of Vioja Mahakamani. I would want us to improve on that aspect of Vioja Mahakamani so that we use this and through the linkages with the universities to be able to sell the message of the judiciary to the law schools. I'm thinking about these border riders in very many centers. They have a stake in the judiciary. I would want us to have set up some kind of way in collaboration with the NGOs to be able to reach out to the border riders, to be able to reach out to these traders at open air markets, to be able to reach out wherever, so that they also get to know about the judiciary. And I have thought through this, Honorable Chair. I would want to package 4 points. Number one, how does the judiciary work? Number two, alternative dispute resolution mechanisms. Number three, obeisance of court orders. And number four, corruption. If we're able to package these 4 points, which can be packaged in a 15 to 20 minutes presentation, sell it to our border riders, sell it to people everywhere. They will be able to move with us. They will be able to co-own the judiciary. They will be able to feel The judiciary is theirs. Honorable Chair, I think in terms of one of the things I will do is to try and make the judiciary people-owned. I want the people to own the judiciary. Once we get them to own it in that manner, where they have a lot of information about it, where they are able to associate with it, where they are able to feel what it does, then should we want to know about corruption in the judiciary, they will tell us, because they are the people. We live amongst them. They know us. Should we have challenges with obeisance of court orders, they will help us. In the same vein, Honorable Chair, I did talk about mending relationships, but I didn't go further. Allow me half a minute to do that. I'm alive to the fact that in Parliament we have specialized parliamentary committees. One in charge of justice and legal affairs, finance, what. But in my thinking, each member of Parliament has a stake in the judiciary. I would want us to reach out to every member of Parliament. We have a category of representatives called women representatives. I would want the judiciary to engage with that category. So when they go back to their constituents, they are able to sell the message of the judiciary. We have senators, Honorable Chair. I'm not talking about committees at this point. I'm talking about senators as representatives of various counties. I would want us to engage them so that as they go about their duties in their counties, they are able to sell the message of the judiciary. We have the Council of Governors. That is at an official level. We have the MCAs. These MCAs also have annual conferences. I would want the judiciary to be present at those conferences every time they are holding a meeting. There's an association of speakers of counties. When they are having their meetings, I want the judiciary to be there. So that way then we carry the judiciary to that place. Now, staff. I said I bring out the best in others. Honorable Chair, with respect to staff, I have 2 to 3 things to say. Number one, the question of transfers of staff where small families are hurt. Employees of the judiciary are as well entitled to the protection under Article 45 as any other Kenyan. I would want us to have a serious review of the transfer policy and ask the Kenya Magistrates and Judges Association to tell us how they want it done. It is their thing, let them bring in that. But then aside from that, we have other employees of the judiciary. I would also want to hear from them how they want it to be done. We get it from them and implement something that we are all comfortable with. Again, still on the staff, Honorable Chair, I want some very serious engagement with staff development under the Bangalore principles. There's talk of competence. I want to improve the competences of all staff of the judiciary. How do I want this done? Through short-term seminars, exchange programs with neighboring counties. The government of Kenya usually receives some scholarships from Japan, Commonwealth, where. As Chief Justice, I will want to lobby for a minimum of 15 scholarships annually devoted for members of the judiciary. So that when we then get them, we have a committee that would have set out rules for allocation and then they are allocated fairly. And with time, we help improve ourselves. Honorable Chair, maybe let me stop at that point.
Okay, just one short follow-up question, Professor. You know, you have talked very well about partnerships, you know, with universities, with other Kenyans and all that, and that is all good. But if Kenyans are looking for an effective judicial system that works, Professor, give us 5 indicators. You are also a researcher. Give us 5 indicators that you would think about that define an effective judicial system. Just 5.
Honorable Chair, an effective judiciary would be one where people can take their disputes and the disputes are resolved very quickly. Quick resolution of disputes.
Mm-hmm.
An effective judiciary would be one where when people walk in, they are treated humanely. That welcome. An effective judiciary would be one that is able to effectively communicate with Kenyans. The judiciary exercises authority that is given to it by Kenyans. There must be some way of effective communication. An effective judiciary, to me, will be one where those working in it feel comfortable to work in it, feel proud to work in it, look forward to waking up to go and work. An effective judiciary, to me again, in terms of accountability, is one where each member can say, I made a contribution. I have done that. I have done this.
Okay, Professor, thank you very much. I will now request the acting CJ to continue the questions.
Thank you. Under the instrument internally that we call the Sustaining Judiciary Transformation, which we see as our true north inside here currently, we have initiated a revamping of the central administrative structures within the judiciary. In your preparation for this interview, you must have come across that. If you did, I will continue to use the word discuss. I'm not a professional interviewer, but if you don't like the word discuss, you could use any other one or ask one of the rest of us to tell you the right word. So I'll ask this professor. Please discuss the rationale for that significant reorganization that we have done under the Sustaining Judiciary Transformation. Tell us what the objectives are and how you as our Chief Justice will enhance those ones or change them to improve the way we do things in the judiciary.
Thank you, Honorable DCJ. In terms of rationale, it is standard practice that any organization should periodically look inside at itself to find out what is working, what it's doing, what it's not doing well, reflect on it, and propose changes. The rationale of that reorganizational structure is to enhance efficiency in the provision of services in the judiciary. Now, in terms of specific objectives, one of the objectives is to was to do a kind of a job analysis to find out whether there is duplication, whether there was reason for mergers, whether there's need to designate jobs differently. The other one was the grading classification, whether the existing grades are serving the judiciary well, or whether there's need to improve on the grading system. The third one, I think again driven by the same thing, is to try and see if there can be some way of worker satisfaction within the judiciary, so that you don't have a situation where a cleaner is earning more than a resident magistrate, or say an accounts clerk is earning more than a judge. So, classification of the jobs, job analysis, and trying to infuse efficiency. The Honorable DCJ asks me, what would I do differently? I have looked at the proposals. I would say I'm in agreement with the proposals. I would want to give them a run the first 3-4 years, and that would be time to review again, especially when we are reviewing the next strategic plan. For now, this has just been done. A new strategic plan is about to be rolled out. Let us move with them to the new strategic plan.
Thank you, Professor. What about the same description, but in the leadership structure? What have we just revamped in the leadership structure? That was administrative leadership under SJT.
Yeah, in the leadership structure, I did not see much, but I would want to say that that is something I would want to look at what there is in order to see whether it's serving us or if we need to improve on it. Yeah, I just want to mention very quickly, Honorable DCJ, that I did see the Commission has committees it works with, and that is very, very good for governance purposes.
Sorry, Professor, I'm talking about the judiciary, not the Commission.
Yeah,
the judiciary, the leadership structures. Professor, as our team leader, as CJ, I doubt you would succeed alone. Maybe you would, but I would have thought that you would work with teams, which is what you said earlier in answer to questions raised. You said you are a team builder. And the latest instrument we have in here is the formation of some central leadership structures. If you haven't encountered them, that's okay. Then we go to the next one.
I have not encountered them, Honorable DCJ.
Thank you, Professor. The judiciary is also in the process, the judiciary, not the Judicial Service Commission, is in the process of implementing a robust alternative justice system. We just launched not too long ago what we call the AJS policy, the Alternative Justice System Policy. Professor, this is the question flowing from that. What, in your opinion, is the relationship between alternative justice systems and the judiciary?
Thank you, Honorable Chair. Alternative dispute resolution systems are recognized under Article 159 of the Constitution, where the Constitution commands that they be given a place. The jurisprudence from our courts has also been very emphatic that where mechanisms for alternative dispute resolution exist, they should be exhausted before one runs to the court. So in terms of where they stand in relation to the judiciary, that is already in the law. However, implementation is the challenge. And I think this is also one area I need to mention that I would want to work on. At the moment, we have the court-mediated dispute resolution mechanism. But then, who are the mediators? What qualification must one have to be a mediator? Who regulates the mediators? So, one of the things that I would want to really move on very fast is to have some form of regulation of these mediators, some form of regulation of persons involved and participating and contributing to alternative dispute resolution.
You don't think we have that in place now?
Pardon me?
You don't think that we have that in place right now?
I have seen something, but I have not really seen regulations like if a mediator misbehaves, this is the body that will punish them. At least in Uganda, mediators are part of the court. Judicial officers are trained to be mediators and they are part of the court system. Here, we have very many mediators out there. We have very many people calling themselves certified public mediator. They are not under the control of the judiciary, but I'm looking at a situation where we can bring all this under one roof so that there's some form of control and coordination. Honorable DCG.
Thank you, Professor. And that would, of course, be your way of improving AJS, so to say. Let us go to the second one. I have 4 broad areas to cover within 30 minutes. Now, one key component of courts' institutional structure is that the judiciary is organized as a hierarchy, which has statutory authority. That being so, that hierarchical arrangement can cause both problems and both opportunities for judges, for magistrates, for all of us in the judiciary. Now, from that statement, I ask this question. What is the administrative and judicial structure of the judiciary? How do those structures interrelate? Is that hierarchy created by law important? Is it important at all? Or is it something that is now due for review?
Yeah, thank you, Honorable DCJ. Indeed, the judiciary is hierarchical. We have the Supreme Court, Court of Appeal, High Court, Employment and Labor Relations Courts, Environment and Land Court, each with a designated head who then coordinates the activities of that court in terms of opportunities. It makes it very easy to manage affairs within a given court. Even as I say this, at the various court stations again, there is an administrative structure with a designated head, and that is good for coordinating activities in those court stations. Now, Her Honor asks, does that pose any problems? In terms of problems, I wouldn't want to look at problems. I would want to look at a situation whereby there is some kind of forum where the leaders of the various courts can come together and discuss matters relating to their courts, matters relating to the judiciary in general, with a view to having a smooth functioning of the judiciary. I think that's all I can think of on top of my head right now, Honorable DCJ.
Thank you, Professor. The Judicial Service Act contains provisions for both the judiciary and the Judicial Service Commission. Chapter 10 of the Constitution of Kenya 2010, under the heading The Judiciary, establishes the Judicial Service Commission. The Chief Justice is the chair of the Judicial Service Commission, and the Judiciary Chief Registrar is the secretary of the Judicial Service Commission. With that background comes the question: is there a demarcation between the Judicial Service Commission and the judiciary? In case your answer is yes, what is the importance of any such demarcation?
Honorable Chair? Sorry.
Yes, let me just finish. In case there is no demarcation, then give us the pros and cons of that situation as given in the Act and the Constitution 2010.
Honorable DCJ, there is a difference between the Judicial Service Commission and the judiciary. The heading of Chapter 10 is judiciary, but under that, then we have these two bodies. However, I think it's Article 160 that then goes ahead to define the judiciary to mean something more specific, excluding the JSC. In terms of functions of the JSC has very specific functions. And my understanding of those functions is that the JSC is supposed to be like the policy giver, the overarching body, because then it does recruit judges, it does discipline judges, it does recommend for appointment persons deemed to be fit to hold those offices. It also has an obligation to promote the independence of the judiciary. Now, what is generally understood as judiciary is that part that is then made up of the court system. And then her ladyship asks, what is the importance of that demarcation? The importance of that demarcation is contained in Article 160, to my understanding. Under Article 160, judicial officers are supposed to make decisions without looking over their shoulders. Judicial officers are supposed to make decisions considering only the Constitution and the law. Now, that then bars the JSC from interfering with the decision making of the judicial officers. So the JSC, in terms of architecture, then sits there as the apex body, guiding whatever is going on, but not interfering. Number one, with the day-to-day operations that are under the Secretary of the Judiciary, and number two, without interfering with the day-to-day management of the courts.
Thank you, Professor. Those are just two of the roles of the Chief Justice. What other roles would you, as our Chief Justice, have to play? Institutional leadership roles.
Honorable DCJ, the other role is to chair the National Council on the Administration of Justice. The other roles are kind of overlapping, like swearing in the president, deputy president, swearing in advocates.
Those are under the Chief Justice.
Yes.
So let us remain with the one you have already given, the NCAJ.
Yes.
Professor, as chair of NCAJ, what would be your priorities?
As chair of NCAJ.
And as you tell us your priorities, you tell us the challenges they currently face and your solutions for those challenges, please.
Very well, Honorable DCJ. The NCAJ brings together very many actors at one table. These actors come with their own challenges from their institutions. But the whole point here is to try to coordinate the administration of justice. Now, the challenges that then bedevil NCAJ will be institutional, coming from the respective institutions themselves. For example, if the prisons has challenges with motor vehicles for transporting remandees to court, we can discuss it at NCAJ, try to work out solutions, but unless the transport situation is improved with the prisons, we shall have either the remandees not showing up for their mentions and court appearances and so on. The ODPP, something common to all is the one of digitization, Honorable DCJ. These institutions are at different levels of digitization. So if we talked of having virtual mentions, some will be able to log in, others won't be able to log in, and that then affects the administration of justice. So one of the main challenges that I see is one of digitization, and that is one that I would want to really impress upon participants, or rather members of NCAJ, to prioritize in their various institutions so that then the ODPP is able to participate in court hearings from the offices, the prisons, the police,
thank
and
you,
so on.
Professor. Let's go to the next one. A prominent jurist once asked, I quote, "How are we judges to deal with political problems that have taken a legal character?" Can he address that question? And cite relevant examples to us. 1, 2, what challenges, if there are any, that you feel the increasing litigation of politically charged issues through our courts poses for the judiciary?
Very well, Honorable DCJ. Politics and the judiciary. The first case that comes to mind is Madison versus Marbury, in which the Supreme Court was called upon to make some decision, and the court said, we leave it for the political players to do their part. Honorable Chair, today is Thursday, I think beginning of the week, end of last week, we had a decision in the case of Ndi versus the AG on the BBI. And the court said, look, we cannot interfere with the proceedings going on in the county assemblies and parliament, but we can wait to look and interrogate the final product. I think That way, the courts are able to navigate the political landscape, number one, by exercising restraint and allowing other arms of government to do what they are supposed to be doing. But at the same time, if called upon, now check whether what was done in line with the Constitution and the law. Now, her ladyship asks, what challenges, the question is what challenges that process?
To the judiciary?
To the judiciary, oh, lots of challenges. Honorable Chair, I was watching an interview by the CJ of South Africa, Mohoeng, and he said, where the three arms of government are working very well, there will be tensions. But the whole point is, it's important that they talk to see how to ease the tensions. With respect to the judiciary, when the judiciary, say, declares an action or a law as unconstitutional, then it's looked upon as being activist, as interfering. And it is annoying. Naturally, all of us like appearing like we are well, we are good, we are doing the right thing. When we are rudely reminded that what we have done is bad, it injures one's ego. So then, through such actions where the judiciary is actually doing its work, it can be quite injurious. 2 days ago, we have this decision on the CAS, that Cabinet Administrative Secretaries. I haven't yet had the Honorable Attorney General comment on it, but that is again a decision that is backed by law, and yet one that is bound to rattle feathers that would draw anger against the judiciary. So yes, in performing its duty, the judiciary will be looked at as interfering with the other arms.
Let us complete that discussion by hearing your comment on judicial legislation. Can the judiciary legislate?
Honorable DCJ and Honorable Commissioners, the Constitution is very clear. In creating the three arms of government, there are functions. Allow me to quote this long-serving former DCJ of South Africa, Dihang Moseneke, who says, when we talk of separation of powers, number one, there must be separation of functions. Number two, there must be separation of institutions. Number three, there must be separation of persons. So you don't have a person serving as a minister and at the same time serving as a judge. And number four, the judiciary must focus on what it's supposed to do. Now, the question whether the judiciary can legislate or not, the straight answer, first of all, is no. But then now, generally, it is also said that in the process of legislation, the legislature may not be able to take care of minute details that are bound to arise in the course of implementation of a given statute. There then, the judiciary is called upon to interpret. In the course of that interpretation and clarifying things, one may then be said to be legislating, but strictly speaking, no.
Is there such a thing as judge-made law? And in relation to Article 20, Sub-Article 3, on enactments that impact the Bill of Rights and Fundamental Freedoms under Chapter 4, is the court not asked to develop the law to the extent that it does not give effect to a right or a fundamental freedom, and adopt the interpretation that most favors the enforcement of a right or a fundamental freedom.
Honorable DCJ, the courts are called upon to do that, but within the law. However, I also said that in the process of interpreting the law, in the process of giving clarity to the law, the courts are bound to come up with something useful which had not been foreseen by the legislature. I have in mind very quickly the case of Mitubel. For a long time, we talked about title to land, ownership of property, but we had never thought of the right to housing, and housing kind of standing alone even on land that is not yours. To that extent, the Supreme Court interpreted the law to give effect to the intents of the Constitution and to promote the rights and freedoms of the people. Now, strictly speaking, it is not judgment law, it is interpretation of the law.
Thank you, Professor. In 2020, the Supreme Court amended its instruments, the rules, the election petition rules, and so on and so forth, to enable it to better effectively discharge the functions or the mandate given to it under the 2010 Constitution. Would you like to mention a few of those amendments if you have come across them?
Honorable DCJ, I have not actively interacted with them.
Asante, Professor. Finally, from this end, when you come in as Chief Justice, there's an extremely important role that I was waiting for you to mention, but let's discuss it very briefly now, that you will perform. That of being the President of the Apex Court. You come in now and find judges who've been there since 2011. Yet, you are the first among those judges, and by the Constitution, you are the team leader. Okay? Please tell us what attributes that Professor has that will bring seamless cohesion in that court. 1, 2, make you the jurisprudential head, as you have to be that. And 3, to solve discomfort when once in a while it happens. What do you bring to the presidency of the Supreme Court of Kenya, Professor? And with your answers, I wish you well.
Thank you, DCJ. In terms of cohesion, I have worked in committees, with committees, I have headed committees. I believe I have the skills to build a cohesive team. In particular, I am a good listener. I encourage others to speak out freely and without fear. I consider the viewpoints of others. I consider concerns of others. I believe in consultation. I believe in giving each person an opportunity to do their best, to bring out the best in them. I have also learned over the years that as human beings, we also have our own weaknesses that we may bring with us to the job. Now, I have learned also how to help overcome that so that that does not derail what is supposed to be done. So, in terms of team building, being team leader, I would say I have the requisite experience gathered in institutions in Kenya and abroad. I have no challenge with that. Honorable DCJ asks about jurisprudence.
Jurisprudential head.
As the jurisprudential head, number one, personally, I have been a teacher of the law since 2010. So I can say I'm fairly well versed with the law. And I'm using the word fairly well versed with the law. In terms of building jurisprudence from the Supreme Court, and without any fear of contradiction, I want to say it here and now, that each judge will write their own judgment. I find it very useful when I'm quoting a case from the House of Lords to be able to say, Lord Atkin said this. I want a situation where our scholars, our students can be able to say, yes, according to Justice so-and-so in his or her concurring opinion, this person said this. Each judge will write their own judgments. Supreme Court, Court of Appeal. I'm extremely uncomfortable with these group judgments.
Thank you, Professor.
Also,
the final one?
No, I haven't finished.
Sorry.
There's the bit about resolving discomfort.
Yes.
Honorable Chair, if there is discomfort, I would want it to be laid on the table. What is the discomfort? What is the source of the discomfort? How does the discomfort relate to the work to be done at hand? Judges of the Supreme Court are employed to do certain things. So I want to know how that discomfort relates to the goals that have to be achieved. Then we discuss that, thrash that out, and move on and move forward as a team. Sorry, DCJ.
No, that's fine. It is the attribute you have. There's discomfort everywhere, including in our homes. There's discomfort everywhere. So the question was what attribute you would employ to bring the discomfort back to comfort.
There are thank you, Honorable DCJ. One of them is that of empathy. I would want to put myself in the mind of that discomfortable officer to be able to understand the discomfort from that person's point of view. And having so done, then engage with the person and hear the solutions that the person himself or herself prefers, then we'll pick out what works.
Thank you, Professor. And back to Professor Chair.
Thank you. Thank you, DCJ. Thank you, Professor. I will now request the Honorable Commissioner Judge Wasame to continue the technical questions. Judge Wasame.
Thank you very much, Professor. Prof, I have looked at your very impressive CV. You have been at Catholic University, Mount Kenya University, Daystar University, KU, associated with Pwani University. You have also been in university in Zambia, Rwanda, Namibia, Botswana. I've also seen that you have done your LLB, LLM, and the PhD in the University of Nairobi. Any reason why you avoided to go back there?
Honorable Commissioner, when you say go back there, is go back where?
To the Mother University of Law.
Honorable Commissioner, in terms of the other universities and looking at the CV, it is set out in a sequential manner. I taught at the University of Botswana 96, 97. I moved to the University of Namibia. Having so done, I didn't have to go back to the University of Botswana. I taught at Catholic University. When my tour of duty was over, I moved on to Mount Kenya University, Daystar University. There's the question about Kenyatta University. I served Kenyatta University for a whopping 13 years before I moved. I look for new opportunities. I looked for new opportunities.
So any reason why you did not go back to the Mother University? That's what I'm asking. I don't know whether you got my question. Prof.
Honorable Commissioner, which is this university that the Commission has in mind?
The UN.
Honorable Commissioner, I have been a student of the University of Nairobi 4 times. I have never been an employee of the University of Nairobi.
Okay. The other thing which I have seen is that your movement from one university to another has not been very steady. You move from one university to another, to another, to another. There is a concern by some scholars and legal practitioners that the court where you want to be the head has the same nomadic tendencies like yourself. You know, when we were growing up in Northeastern, where I come from, Mandera, when the schools close, we will look for our families in the bush. So when you reach 50 kilometers to where you left the last time, you are told the family has moved to another area, and you start looking. Maybe you spend almost half of the holiday or 3/4 of the holiday looking for the family. There is concern that this court where you are going has that nomadic tendencies of moving its jurisdiction from one area to another area, and that legal practitioners, in fact, one of the stakeholders told us that it is difficult to advise clients and litigants on what you can get from the Supreme Court. Combined by that nomadic tendencies of the court and the nomadic tendencies of professor, how do we trust you with the court?
Thank you very much. This is how you trust me with the court. What is being described as nomadic tendencies is nothing other than a wonderful exercise of the right to employment. An employment relationship always has an escape clause. An employee can be sacked under certain conditions. An employee can leave. So, all I have done is to exercise my right to employment. Try to move around, gain experiences. And my friends from central Kenya usually tell me that a person who has traveled has seen a lot. I would want this commission to trust me to that extent that I have seen a lot through what the Honorable Justice Wasami describes as nomadic tendencies. Now, with respect to the jurisprudence from the Supreme Court, Honorable Commissioners, the Supreme Court is very young. I would not want to pass a harsh judgment on it at this stage. It is still evolving. I would say, let's give it a bit of time. The jurisprudence will settle with time. People will be able to know exactly what to expect when they approach the Supreme Court.
Thank you very much, Professor. That's all for me. Thank you, Prof.
Thank you very much, Judge Wasame. And now I'll request the Honorable Commissioner Judge Bajaja to continue the questioning. Judge.
Thank you, Professor, and welcome, Professor. I just want to follow up from a question my colleague, the Honorable Acting Chief Justice, asked you, and you answered that you prefer individual judgments. But there are circumstances where you, as the Chief Justice, will want one single unanimous joint judgment. Can you tell us what kind of circumstances this could be?
I can't think of any at the moment. All I can say is that even if it's a single unanimous, then it should be indicated so. But that should be the exception rather than the rule. Currently, the rule is a joint judgment.
What I want to know is what are these kind of circumstances that you as Chief Justice, you will tell your brethren and sisters that colleagues, let us give one single judgment. What are those kind of circumstances?
I could think of interlocutory applications. I could think of, applications for certification for an appeal, where we have at least two judges sitting to decide on that. I'm unable to think of any other specific circumstance.
Okay. I've been asked, one of the tasks I've been asked is to look at your writings, and I must say I am impressed by what you have done. You have done scholarly writings. First one is an application of an article on the presidential election petitions. You have also been involved in international decision making, which is important. An article on international sports. You have also written submissions, and you have published a book on judicial review. So I want to ask you just, and they're all good, and it is a credit to your learning that you have been able to combine both the law and your interest in sports. You have been involved in international decision making. Can you just give us what important lesson in terms of international proceedings that you would come with to improve case management and case flow? Maybe just give us two examples.
Yeah, thank you for that, Honorable Commissioner. Indeed, I participate in international decision making at the Disciplinary Committee of World Athletics and at the Ethics and Disciplinary Committee of the International Weightlifting Federation. In what we do there and what I think the kind of experience that I come with in terms of case management is that when a dispute is registered, we have a secretariat akin to a registry that registers that, asks for additional documents where necessary before a panel is put together. Once a panel is put together, then we meet, the materials are shared out, then we meet first as a panel to discuss the material to identify areas where we need clarification, and thereafter we invite the parties. And Honorable Machenj, I'm glad you asked this, because again, this we do it virtually. Like for the one I submitted, the Russian athlete Bakulin, he was sitting in Moscow. The secretariat is in London. I was sitting in Nairobi. My other colleague was, there was another colleague in London, another colleague in Belgrade. Then there was a specialist witness in California. The advocate was in New York. Then there was another witness in Australia, and it was quite interesting, and it's quite interesting bringing the whole world to a court session, irrespective of the varying time zones. Now, after we hear the parties, then one of us is asked to draft the opinion. Within a certain time, it is then circulated for input by the others. And let me also say that at that level, the opinion is actually a unanimous one. We are not required to write separate opinions. Now, after we circulate and agree on the final draft, then it's brought for signature, submitted to the secretariat, who then publish it.
Okay. What I want to know is, what are your strategic, because you are aware, although in the last 5 years we have made tremendous efforts in reducing backlog, what are the strategic interventions you would make to deal with the issue of backlog, particularly given the COVID situation that has affected delivery of justice? Just give me 2 strategic interventions.
One of them is where I started. Sorry. Let us talk to Kenyans. Let us educate them. Let them be able to take a conscious decision whether they want to come to court or they want to avail themselves of the ADR. In the process, we reduce the people coming to court. That's number one. Number 2, I mentioned about a 4-point agenda for sharing with the public. One of them is, and the last one was corruption. If we are able to sensitize our people on the ground about corruption, so that they are able to make noise, able to blow the whistle before the corruption takes hold, then we shall have very few people appearing in the anti-corruption courts. We reduce the backlog there. Then, of course, thirdly is the enhancing the use of ICT in terms of courts management and so on.
Okay. One of the books you have written on is on administrative law, and a book on administrative law. Can you just briefly tell us how the Constitution 2010 has changed the landscape of judicial review? Maybe 2 ways in which it has changed the landscape of judicial review, pre-2010 and post-2010.
Yes. 2 quick ways I can mention is that, number 1, everyone is bound by the Constitution, both private and public entities. I remember in 1993 when player Odumbe sought judicial review because the International Cricket Council had banned him. The court said, sorry, we only deal with government entities. So previously judicial review was seen to be being used to control government entities only. Now it applies across, and this has been said many times by decisions from many times, and rightly so, by decisions from the High Court and other courts. And the whole thinking here is that we are all bound by the Constitution, we are all bound to respect human rights. The other way in which the Constitution has changed the outlook to judicial review is in the manner of approach. For a long time, we relied only on the common law approach, or first of all, seeking leave of the court before filing the notices and so on.
So that is a procedural.
That is a very useful procedural change that has been brought about.
Now, just on that particular issue, there are those, put it this way, part of, and this is usually referred to, I don't know, constitutionalization of judicial review. Since Article 47 came in, and then we have the Constitution, and we still maintain the common law, what problems do you see going into the future resulting from these varied channels of judicial review? Or is it, first of all, is it a problem? And if so, why not? Or if it's a problem, can you tell us why?
I want to say that it is a problem to the extent that it is a bit confusing to the practitioners. One may not know exactly when to approach the court by way of petition directly or by way of seeking leave of the court, the common law approach of judicial review. That area needs to be straightened. It is not very clear to practitioners out there, and more so to the litigants out there. But then Article 47, together with the enabling statute, the Fair Administrative Action Act, they outline clearly, the main focus is that other alternative remedies should be sought before approaching the court where they are available and if they are effective.
Okay. So you have no problem with the existence of various streams of judicial review or administrative action?
I don't see a problem with that, and maybe my lack of seeing the problem is the transition, kind of what I would call the transitionary phase in which we are from the older ways of doing things to the newer ways.
Okay. Now, you have been involved in sports, and I think and in part of your readings, I see some of the issues you have raised. We have the sports tribunal. The sports tribunal, and it is created under the Sports Act, isn't it?
Yes, Section 55.
Section 55. Now, is there a right of appeal? Is there a right of appeal against a decision of the sports tribunal?
Thank you, Honorable Commissioner. There is a right of appeal, but two tracks. If the dispute at the sports tribunal involves sports bodies, after the sports tribunal, the next port of appeal is the Court of Arbitration for Sport. And this is laid out in the international statutes of those sports bodies. They don't want their matters held up in courts.
Okay. I just want to say, so you agree that under Section 55, there is no right of appeal to the High Court or to the ELRC or to the Court of Appeal or the Supreme Court?
Honorable Commissioner, I had not finished.
No, I don't. I am just asking a specific question.
No, there is a right of appeal.
Under Section 55.
Section 55 may not specify that. It doesn't specify that.
So if a statute does not specify a right of appeal, like Section 55, is there a right of appeal to the superior courts?
Yes. And I would say yes, because there's an article I'm not remembering very well, but we are all entitled to justice, and justice here demands that we be able to exploit all avenues of dispute resolution available, and most available under the Constitution.
Okay.
And under the Constitution, tribunals are classified under subordinate courts. That makes it already a route to go higher in terms of appeals.
So despite the fact that there is no right of appeal in Section 55, you can still go to the higher court. Okay. So the other issue is that the tribunal has a special jurisdiction under the Anti-Doping Act. And in that jurisdiction, the right of appeal there is to the Court of Arbitration for Sports. If you are dissatisfied, you go to the Court of Arbitration for Sports. Now I want to ask you, where is this Court of Arbitration for Sports located? Or it's virtual? I don't know. You tell us.
Honorable Commissioner, the Court of Arbitration for Sport is physical and located in Lucerne.
Okay. Lucerne, that is in
Switzerland, yes.
Okay. Now, if you are an athlete in Kenya, say you are from a village called Cheptongei in Marakwet, and you have a small dispute, and for whatever dispute, it means if you are dissatisfied with our local tribunal, the statute forces you to go to Switzerland if you want to appeal. Now, under Article 48, what is the state obligation in terms of ensuring your access to justice? You are from Cheptongei, you cannot afford 10,000 USD to lodge an appeal. What is the state obligation to ensure the access to justice in such situations?
The state obligation is to avail the necessary legal and institutional fora which are availed. However, with respect to sports persons, these are also governed by the international rules. Under the international rules, there is an attempt to subject sports persons to uniform law globally. And this is why an appeal will then lie to the Court of Arbitration for Sport. That is number one. Number two, in matters doping, the World Anti-Doping Agency has a stake. The international bodies are interested. They cannot come to file an appeal in a local court.
So the issue I'm asking, if I'm a poor Kenyan, the state has given away my right to access to justice. So the issue I'm asking is, what is the obligation? Because the state, this is a fundamental right of access to justice, that I am dissatisfied with a local tribunal, but you're telling me to go to Lausanne. So what is the state obligation, and how is it promoted, protected, fulfilled? So you tell me, because you were involved in the drafting, what did you contemplate that the right of any person who is aggrieved will be protected, promoted, fulfilled in terms of telling me to go to Switzerland? How was that to be achieved?
That was to be achieved First of all, through the understanding that sport and participation in sport is a private affair. It's a matter of choice. One chooses, one does not choose. In terms of state obligations to facilitate, I'm not aware of any. We did not think about that at all. All we contemplated, and what is contemplated, is that a person has freely chosen to participate in this. Now the person has an obligation to obey the rules of that sport, and under one of those rules is to appeal to Lucerne, not locally.
Yes, and I don't want to flog the horse. This is now a statutory provision. You know, it would be different if there was no statutory provision.
Oh, yeah.
It would be different that it's just me and the Boxing Federation or the athletics, and we have our dispute. But now, the state, my state, is telling me to go to Lucerne. So isn't there an obligation on the state, which you as the one of the drafters of this ought to have borne in mind in terms of promoting, facilitating, protecting that right, Article 21, in respect of this?
I think there is an obligation of the state, but then the obligation would take the nature of the state availing, say, council for the purpose.
Okay. Now, just on the same issue of administrative law, we have been told many times that judicial review deals with the process and not merits. I think that is general. But there are circumstances where the court may delve into the merits under judicial review. Are there such circumstances?
I would say the main purpose is actually to interrogate the process. But in interrogating the process and arriving at a final decision, that could appear like the merits have been dealt with.
Okay. And just on that particular issue, one important administrative intervention in Kenya has been the establishment of the office of the ombudsperson, that is encapsulated in the Commission for Administrative Justice, one of the hallmarks of good administration, and to be able to resolve citizens' grievances and to subject public bodies to a certain standard of administrative behavior. Do you know what is the latest decision by the Supreme Court on this particular issue of the ombudsperson, of the office of the ombudsman?
Yes, that is the matter of Vision 2030.
Yes,
versus the Commission on Administrative Justice. Yeah.
You've read the decision?
Yes, I have.
You have read the decision. And this, I want to ask you because it's just an issue of adjudication. In that decision, the court gave certain guidelines. It gave certain guidelines, am I correct? Regarding the nature of the decision.
Yeah.
It gave certain guidelines. And you have read other decisions of the Supreme Court where it gives guidelines. From a point of view of development of jurisprudence, in your view, is that a good approach to give guidelines or to deal with a specific case? You tell us in terms of development of jurisprudence as an apex court.
In terms of development of jurisprudence, it is good to do both. Maybe not in the same matter. Now, in terms of giving guidelines, these guidelines eventually guide other courts in resolving similar disputes. So jurisprudentially, I would not fold the approach of giving guidelines in decisions the way the Supreme Court has done in that one and in several other decisions. Now, you raised the question, what about just dealing with the dispute itself? Of course, it is in the process of dealing with the dispute that then a bigger picture emerges that then requires some kind of guidelines, and this is also in light of what I had been asked earlier, whether judges make law. Through the giving of those guidelines, they assist other courts. So I see nothing wrong with that.
Okay. I'm sure you have been watching these interviews from day one.
Your Honor, I'm not sure whether you are making a statement of fact or
No, I'm
presumption.
asking, I'm just asking you. You are the second last candidate, so you have been watching the interviews, and you know what kind of questions will be asked, just the way we used to read past papers, and you try to answer them. So I just want to ask you, because we've asked everybody on the Muruatetu case, you know the Muruatetu case, and we've discussed it with the other candidates, the Muruatetu case. One of the issues that has come up, and I just want to hear your view on this, is that you know what the case was about, the mandatory nature of the death penalty, and there are those who have said it has had certain consequences. For example, what consequences has that had on other areas of law in Muruatetu? The court said the mandatory death sentence is unconstitutional. So what other consequences has that had on other areas of law?
Yeah, we have other statutes where there had been where maximum sentences had been prescribed in the law. For example, in the Sexual Offences Act, the Muruatetu decision has had an effect on that, and now judicial officers are applying that decision in those and in similar cases where a maximum sentence is prescribed by law.
In your own view, do you think that is a good thing, or you think the the superior and subordinate courts got it wrong?
The main argument to me is very persuasive. That is to say, if we just say this the maximum sentence, then that takes away the discretion of a judicial officer to consider any mitigating circumstances. And that kind of puts all crimes by one name in the same basket when they may not all be the same. So I think that taking of that, to me, is good, and it's helping our people. It has freed the hands of judicial officers.
Okay. So there are those who say that, in fact, the court should have said that this principle, is limited to this case only, and it should not be followed in any other case. What do you think? Do you think that is a problem for an apex court to say so? Say, we have heard you, Muruatetu, we agree with you, but this principle is only applicable to this case. As an apex court, do you think that is a proper approach to dealing with that kind of an issue? To make it very clear in that sense.
Honorable Commissioner, one of the obligations of the apex court is to establish jurisprudence, set the law to be followed. Now, in a situation where the court would say, we have looked at all this, but this applies only here, that would leave a lot of open gaps. And that will not be good guidance to the other courts, especially the courts below.
Okay. On to another area. You are a dean of a law school in a church-affiliated in a church-affiliated university. In fact, this is I'm told, and correct me if I'm wrong, you start your classes with morning devotion. Am I right?
Yeah, we pray, yes.
You pray. Now, if I were a Hindu or a Muslim or any other religion, do you see that as a problem for a university that is public in nature?
Yes, that would be a problem if the university or such a university compels those of other faiths to adhere to that. Let me also mention that I have worked at Catholic University, which is also faith-based, and we had students from all over. At Daystar, in fact, the majority will not be here. We have quite a number of students who profess the Muslim faith.
Okay. So you are familiar with the decision of the Supreme Court in the Fugicha case? The hijab case?
Yes, but let me also say that I liked the one of the Court of Appeal better.
You liked the one of the Court of Appeal better. So there are two issues. If you are on, there are two ways you can look at it. In your view, let's put it this way: the majority of the majority of the Supreme Court took a narrow view of the matter, adopted a formal view, isn't it? You can say it adopted a formal view. If you are seated in that court, where would you fall and why?
Now, that is also a tricky question, because the matters in Fugicha are not yet settled.
No, the Supreme Court matter is settled. So just tell me, I'm not even telling you about the substance. Where would you fall and why?
Okay, now, I would want to fall on the side that considered Article 159 to 2C, where one is supposed to look at matters without giving undue regard to technicalities. My challenge with that decision is one of focusing on the technicalities of Fugicha not having been a party right from the beginning.
Okay. And my final question is, what is the CJ's, the Chief Justice's role in university education? You have been involved in legal education. What is the Chief Justice's role in the university legal education?
To admit the products after they have done their 5-6 years as advocates.
Yeah, the Chief Justice has no role in Council for Legal Education or Kenya School of Law?
The judiciary is represented on the Council of Legal Education, yes.
So what is the role of the Chief Justice in
that would be more advisory. Yeah.
And as a Chief Justice, how would you use your position, and I can see you have also litigated on some of those issues, how would you use your position to influence legal education in Kenya, yourself as a Chief Justice?
Yes, Honorable Commissioner, as CJ, I would do several things Number one, through the membership of the legal on the Legal Council of Education, ensure that the laws, the rules that guide the process of graduation, admission as an advocate, training as an advocate, examinations as an advocate, and eventual graduation are actually smooth flowing to minimize the avalanche of cases we have had in the High Court touching on that. That's number one. Number two, I would want to build networks with the deans of those schools for purposes of having the judiciary have a presence in those schools. As had indicated earlier, I would want all judicial officers who have higher qualifications to adopt at least a university as part of their community service. Offer one class. And then, of course, thirdly, I would want to use the university to propagate some of the work that is done by the judiciary. I hinted at the various moot court rooms, wonderful, very expensive, but which are largely lying idle. If we can use them to kind of make stage plays there on various aspects of the law and eventually broadcast this to the public, we'll be able to reach the public through the universities.
Okay. One final question, and this is a scenario. Somebody has a, say, your neighbor in Nambacha has trespassed on your land, or your brother's land. Your brother sues the other person for trespass, and in the process he says, in the pleading he says, X has trespassed on my land and therefore caused me loss and damage and interfered with my right to land under Article 40 of the Constitution. When the magistrate hears the matter, the magistrate says, well, it's okay, I hold that there has been trespass, and that trespass amounts to a violation of Article 40. Matter goes to the Court of Appeal. The other person is dissatisfied. High Court, magistrate is upheld, says the magistrate is right. Goes to the Court of Appeal. Court of Appeal says magistrate was right. The case comes to the Supreme Court, and the issue of jurisdiction arises. One party says the court has no jurisdiction. The other party says the court has jurisdiction. Where would you fall seated in that case? Of course, not disqualifying yourself, but where would you deal with the issue? How would you deal with the issue of jurisdiction of the Supreme Court?
Thank you, Honorable Commissioner. The Supreme Court has jurisdiction to hear appeals as of right where a matter of violation of the Constitution or of rights is involved. So that is already in black and white, and I wouldn't have an issue with that at all, especially if one is alleging violation of Article 40.
Mm-hmm. So in this particular case, you would be saying that merely because the person said it is trespass and therefore a violation of property rights, the court would have jurisdiction.
Honorable Commissioner, I am saying that if the purpose for appeal is based on the rights or violation of a right, then the court will have jurisdiction to hear it.
So in many instances where we interact with government bodies, there is a violation of a right, isn't it? many instances, even when you're an employer.
Yeah.
Even when you are an employee, you've been wrongly terminated. It is a case for wrongful termination, and in your pleadings you say, I was wrongfully terminated, I need my damages, but it is also a violation of Article, is it 40, I think 41 or something, about my fair labor rights. Does that per se mean that it is a matter that will go up to the Supreme Court, and the Supreme Court will accept that it is actually a matter of fundamental rights and freedoms?
Honorable Commissioner, just the fact of having been dismissed may not be a matter of rights. The right should have been pleaded right from the beginning. So, where from the initial pleadings, that violation of that or related rights is pleaded.
So, you are advising Kenyans that in every case you file, whether it's an accident, please plead a violation of a constitutional right, because the Supreme Court will take your case. Is that a fair assessment of what you're telling me?
Honorable Commissioner, I cannot be heard to be telling Kenyans that, because when Kenyans approach a court, they want an immediate resolution of their dispute, and the focus is finish with us now. They are not looking at the long trail of appeals. However, if parties are dissatisfied and they keep hopping from one court to the next, then the Supreme Court has jurisdiction only in certain instances. And where then one alleges a violation of a right, then that allegation should have been pleaded right from the beginning.
Thank you very much, Professor. Thank you, Chair.
Thank you very much, Honorable Judge Majaja. Thank you, Professor. I think I'll allow one more set of questions from Honorable Commissioner Macharia Jeru, and then we'll take a break. Honorable Macharia.
Thank you, Prof. Let's proceed from where my colleague, Commissioner Majanja, has left. Owners of motor vessel Lillian S. versus Caltex Oil, 1989. Now, tell us what is famous about that decision, so that I can move now to my next set of questions.
Thank you, Honorable Commissioner. I think in that case, we only recite a very small part of it, attributed to the late Justice Nyarangi, namely that jurisdiction is everything.
Yes. Now, arising from that fact that jurisdiction is everything, there is a tendency sometimes of judges, when that issue is raised of jurisdiction, to say that yes, you've raised it, but there are also other issues in your matter. Let's deal with all the issues, then I'll make one decision. Now, what is your position regarding that? And if you are a judge, how, if you are to be in the Supreme Court, how would you deal with it?
Yes, very difficult question. I've seen those decisions. I think it's also a matter of judicial economy. I think the court would be saying, okay, you have raised this, but then you have also raised other issues over which we have jurisdiction. Why don't we handle all this in one, at once? There are other matters which are so clear-cut, or in which a court will clearly see that it has no jurisdiction, and there, as the late Justice Nyarangi advised, the court should lay down its tools.
Yeah, which is why I'm asking if there are matters that are so clear the court has no jurisdiction, then why not deal with them and separate so that you're able now to argue the other issues? I'm just trying to understand now for you, if you are the Supreme Court and the issue of jurisdiction is raised. You are in the Supreme Court and now you're the President of the Supreme Court. So why would you want to combine all the arguments when you have an opportunity to separate, to sift, as it were, it's like sieving. So what would be your position regarding that, bearing in mind what the late Justice Nyarangi stated in that matter?
Honorable Commissioner, I will take a more strictest approach. If I notice that the court has no jurisdiction, we just lay down our tools.
But you've also provided for a scenario where it may have jurisdiction in some, it may not have in other issues. So how do you deal with that kind of scenario?
No, Honorable Commissioner, I was referring to what has happened before at the Supreme Court. If there's no jurisdiction, there's no jurisdiction, the matter stops there.
Okay. Now, let's leave there and we move now to the issue of your CV, because I've also looked at it. It's quite extensive. Now, I noticed that you wear more or less two hats. There's the sports bit of it, physical education, there's the legal. Now, which one is your greatest strength in the two? Where have you been more vis-a-vis the other when you look backward to your career?
Honorable Commissioner, let's not talk about strength. You see, the computers we use have a CPU that famously stores information in specified files, folders, and so on. The human brain has files and folders that intermingle information. So, I cannot say I'm stronger here or stronger there. They are not two separate. I'm able to mix the two comfortably.
No, I'm not doubting that.
Yeah.
I'm using your words. You say that even when you deal with people, when you've been in situations, you look at their strength.
Yes.
That's what you said. So, I'm picking now from there and now asking you the same question you ask others that you deal with. So, you have a lot of experience in physical education. You also have in law. So I'm pushing back the question now to you. Where is your strength when you consider the two?
Then I would want to answer it using the earlier version. Where have you spent more time? I have spent, I think, more time in the law part than in the physical education.
Now, because when I was looking at the universities that you've taught more, it seems like it's more on a physical education. When I try to extrapolate, vis-a-vis the law, there's nothing wrong with having both. I'm not disputing that. It's actually an added advantage, but I'm just trying to distill the information. So if we were to look at in terms of teachings, now from your scholarly work, it seems to me when the papers and everything, it's more on a physical education. Would I be right on that?
Honorable Commissioner, you would not be right in that, in the sense that looking at the papers, I followed the courses of studies in each of those disciplines from beginning to end. So, taking that approach, I'm eminently qualified in both. In terms of what you're asking about the teaching, I last taught physical education, strictly speaking, in 1998 when I was at the University of Namibia. Namibia, that was 1 year, Botswana 2 years. I had been at Kenyatta University for 13 years. That makes 15 years.
15 years.
So I have spent about equal time in both areas.
Yeah, when did you start teaching law?
In 2010.
2010. You say now in 2010 up to now, It's about
Oh,
11.
Yeah, sorry, the teaching, yes, I was combining with the practice.
Yeah,
okay.
that's why I'm saying that the teaching, you've taught more of physical education than the law. Now again, when it comes now to practice, I was looking at when you became an advocate, and you became an advocate. Now you're approaching, say, 16 years of.
I think I'm approaching 17, not 16. I'm already done 16.
Yeah, 16. Yes, so it's 16 now. So I was basically seeing again, it's like borderline because the qualification of a Supreme Court judge, Chief Justice, 15, right? So again, borderline. Now, bringing me to this question now. You see, and I'm not underestimating you. You are eminently qualified. I have absolutely no doubt about that. But you see, we have to compare, of course, also with the other candidates, because ultimately, when you pick that Chief Justice, we must account to the people of Kenya. This is not a position even us as JSC can just dish out as we wish. We must be able to account to the public. So now tell me, in comparison with the others who are also seeking the position, the same position. Now, tell us what is it that you have that you think in comparison with the others puts you a notch higher than them in terms of bringing in transformation in this judiciary, both in terms of experience, in terms of vision. And you see, all this is the issue of burden of proof. You prove by what you've done before, bearing in mind the fact that when people are being interviewed, they can say anything, but we look at their background, what they have in the past, that actually proves that going forward, yes, this is the person. So I don't know whether you could be able to distill that and tell us.
Yes. One of the things that I think I bring on the table very strongly is one of leadership. I have been manager for Special Olympics International in Church of Africa from 1999 December to 2001. In that role, I worked with very many sub-Saharan countries, oscillating between ministerial offices and the sports bodies in the individual countries, doing a lot of diplomacy. I have worked on a voluntary basis at the National Committee of Bioethics of NACOSTI for 6 years as vice chair. I want this commission to know that at the time I got to NACOSTI, about 2011, the country was having certain challenges. For example, in 1992, a researcher from Kenyatta University, in collaboration with some from the UK, did research using materials from Lake Bokoria, extracted some extromophils, the specialized enzymes for bleaching genes. The fellows out there went and patented, ran with it. All the bleached genes we see around here, the materials came from Lake Bokoria, but Kenyatta University got nothing out of that. When eventually it dawned on the university and it started making a little noise, the company equipped the biochemistry lab with computers. And it has now pledged to give 3 million shillings to the community and the Roy's community around the lake. We lost out on that. Getting closer to now 2002-2003, we had this challenge of HIV and AIDS. And one of the methods being propagated for preventing HIV and AIDS was male circumcision. Honorable Commissioners, in the process of pushing that agenda, somebody disappeared with 42 foreskins of Kenyans without their permission, without the knowledge of the government, without anything. While I'm still on, arising from that, while at NACOSTI, we decided to address that problem, that challenge. And what did we do? We developed rules and guidelines for what we call material transfer agreements. So any researchers coming into the country and wanting to do research involving carrying out our materials, they must go through certain protocols so that as a country, we do not lose out. While at Nakosti, Honorable Commissioners, we had a challenge with evaluation of ethical research projects. At the time, only Kenyatta National Hospital, KEMRI, and the Moni teaching and referral hospitals had the capacity to clear ethical research. We developed rules for clearance of ethical projects. We developed rules for accrediting other institutions to put them in that position to clear research applications. And by the time I left, we had now set up about 30 what we call institutional ethics review committees. This means, in practical terms, that a researcher based in Mombasa doesn't have to travel to Nairobi to get ethical clearance. That can be done over there. Still on the question of while at Nakosti, we worked on materials transfer agreements. That is a big relief to the country. We have expanded the manner of ethical review of research. That was a very big concern. And we have also kind of set out what is called operating manuals. So each committee knows what to follow in all standard operating procedures. So each committee knows exactly what to follow in the process of doing that. And we have made it quite easy for researchers. Honorable Commissioners, allow me also to mention something. In the 80s and 90s, for those who may remember, and even early 2000, if AFC Leopards was playing Gor Mahia at Nyayo City Stadium or Kasarani, the city center would be a no-go zone because of rioting and the mayhem that they usually left behind. From 2006, I became chair of the Kenya Premier League Disciplinary Committee, something I did for a number of years. And together with my colleagues on that committee, we agreed we were going to apply the rules fairly and strictly. I want to report here that we did punish those clubs fairly. The clubs realized that hooliganism does not help them, and with the support of the club leaders and so on, I can say we were able to change the culture. At the moment, even if AFC and Gor Mahia are playing at the stadium, people are able to go about their lives freely and without fear. Honorable Commissioners, that was a transformation. While we are still at that, when I became CEO of Kenya Football Federation, a post I held for a very short time, I found there a culture of corruption. Referees, each country is expected to nominate 20 people to participate internationally, meaning they are assigned duties in other countries, they get allowances, stay in 5-star hotels, very comfortable kind of thing. A very much envied thing. The practice then was that these referees were expected to bribe, number one, fellow officials, referees officials, and then the bosses of KFF. I abolished that. And the practical way I did it was to just invite the officials of the referees, tell them, sit in that room, you have 2 hours, give me the list. As soon as I get the list, I forward it to Cairo. So I have that method to deal with corruption. Now,
try to, so that I can move to the next question, try to summarize, please, if you don't mind.
Yeah, I could just stop there so that we see if we can capture that in the
now,
next question.
See, looking at all that, all of it is touching on sports, research,
and the law,
sports and all that. talked about Kenya Premier League, which you may or you may not be aware, I'm the one actually who registered it, set up all those rules, including that committee you're talking about, including even appointment, and all those things. All of them sports related largely. Let's move to legal. So that because see what I'm trying to do is to match your skills with the job that you're seeking, considering that it's a high profile job. Let's go to legal, and you tell me now as a practicing advocate, you give me 3 major cases that have had an impact on development of jurisprudence. 3 major cases, again very briefly, that have had impact on jurisprudence, so that we can trust that Professor Moni, we're not taking a specialist in physical education to the Supreme Court and become the Chief Justice. We're also taking somebody who has vast knowledge in a law and will be the leader of jurisprudence in that court.
Very well. The first one I want to point at, and which shaped the direction that other courts took, and therefore the jurisprudence, was the Odinga case of 2017. Having been decided within that stipulated time, now the other courts had no choice but to
No, Prof. I'm saying a case that you have handled.
Oh, I have handled.
Professor, not
yes, sorry.
The case that Professor Moni Wekesa has handled, that has had major impact on development of jurisprudence. You just give me three cases. Now that we've left the physical education, you've given a lot of achievement, and I agree. I have no doubt. I have no doubt you are an authority in sports, and that's why actually in Kenya Premier League, when you develop the rules, we chose you. I'm the secretary today of the Kenya Premier League Limited, so I know why we chose you and not anybody else. Now I'm looking now for the legal strength, so that you can know, because we're not looking for a Chief Justice for physical education. It's also be a leader of jurisprudence. So you give me 3 cases that you've handled that have had a major impact on development of jurisprudence in the Republic of Kenya.
Thank you, Honorable Chair. Most of my cases have ended up at the High Court. I cannot really say they have had a major impact on the jurisprudence in Kenya.
Yeah. Now, okay, that's all right. I'll not pursue that point any further. Now, what I noted is that you've also had a stint on a political seat 3 times, actually 2007, 2013, and 2017. And 2007, I think it was Labour Party. 2013 was a United Democratic Party. 2017 as an independent. And I must congratulate you for giving it a try again and again. That's a mark of resilience, in my view. Now, but again, there's also a downside to it, because if you are moving from one party to the other, it may also mean that you don't have an ideology. And why I'm saying that, because then it means that you may also be lacking a philosophy that guides your thinking in terms of, when it comes to the legal jurisprudence. Because see, if you look at all the judges, in fact, the famous judges that we even quote, say for instance, like Lord Denning, you can see the flow of the thinking of Lord Denning, Now, if you are lacking in a philosophy that guides you, that could also be a danger. Now again, looking, as I said, is burden of proof. I'm looking at your past. So convince me that you have a legal philosophy. Tell me what it is and why you have, what guides that philosophy.
Very well. Let me start backwards. In terms of political parties, we live in this country and we know that we haven't yet matured politically to really talk about principles. We talk about congregations of willing partners. So it would be extremely harsh to be charged along those lines. Having said that, we have learned very many legal philosophies. My experience is that one applies a legal philosophy to a specific case depending on the facts and circumstances at that point. Generally speaking, I like the sociological school of law. The sociological school of law posits that one needs to understand the society for which the laws are being made. One needs to understand why the laws are being obeyed or disobeyed. One needs to understand the people in that society in order to be able to make appropriate laws. And in fact, here Eugene Ehrlich says, yes, if you want to know whether the Factories Act is working, don't look at the black letter of the word. Go to the factory, see how it is working. Now, with that philosophy, and remembering where I started, this is why I believe that so far the judiciary has confined itself to a certain space. It has not moved to where the people are. And using that philosophy, I would want administratively to move the judiciary to where the people are, so that as they use the laws, as they partake of the judicial services, they are doing something that they can flow with. In terms of jurisprudence in court, all these laws, all these disputes that come, will have a social bearing. When we talk about a case that has made an impact, we are talking about a case that has a significant impact on the society. And that's where now I say there are many schools I subscribe to.
Prof, with respect, what I've heard is more of political statements with generalities, not concise in terms of how your thought would flow, with tremendous respect. And now, you mentioned something that just crossed my mind, where you say that our politics, there are no principles, there are all this, which means that you're explaining why, you opt from one party to the other. But see, that concerns me, Professor, because, we are not looking for an ordinary thinker or somebody who flows with the, behavior of people in terms of how they conduct their politics. We are looking for this principled person who is able to provide a direction. This is the embodiment. This is the face of the judiciary. This is somebody who will be identified also with the development of the jurisprudence up there that could shape how the country moves. Now, if you are ordinary, just like the other guys who are fighting for those political seats and who are changing, as it were, depending on the circumstances you are saying. Now, how then can we trust you as our Chief Justice to provide clear direction based on sound principles?
This is how. Where I serve on the international tribunals, we apply the law and nothing but the law. In my academic writings, I've written about the law and nothing about the law. I am very focused. I can focus on the task and deal with the task at hand. I said it would be very unfair for me to be judged on account of what one is calling moving from one party to the other. However, even that movement from one party to the other has also taught me how to deal with politicians. And here, politicians are useful in availing resources to the judiciary, in helping the judiciary in other ways. I bring in that aspect. C.B. Madan, we adore him. Al Warren, we remember him. These were people who served in political offices at some point or other. I was not lucky to succeed in getting there, but I understand the mind of a politician, and I can engage them as CJ for the benefit of the judiciary.
Forgive me, Prof, if I give you an impression I'm condemning. I would never do that. I would not even judge you. It's just that, as I said, I'm trying to match the skills and the person vis-a-vis the position, so that we can account to the people of Kenya. But I respect what you've done, and I acknowledge that. But which takes me now to the last thing that you said about how you've served in the tribunals, how you've applied the law, and all that. Kenya Rugby Union, of course you are aware about their complaint against which was served to you and which you responded to. But they are accusing you of not actually following the law. Because if you look at what they are saying, is that you are appointed to a Kenya anti-doping task force. And while serving in this task force where you are the chair, you went ahead and firstly never even give them an opportunity to be heard. The rules of, you breached the rules of natural justice, and did your investigations, and then named the coaches and players where you said that that they were using banned substances. In fact, they're saying in their complaint that you went ahead and in some, and mentioning names of coaches of international repute in libelous fashion, that in pages 40 and 41 of your report, you stated that they were using food supplements, that were banned, that were contravening both World Rugby and KFU regulations, and basically saying that they were enhancing, what was banned, what they were using that was leading to them performing the way they were performing. And there was a hue and cry, the whole public, media, and all that. And you actually you made spirited attempts to justify, and to continue, as it were, to rub salt in the wound, condemning them, alive to the fact, the fact that rugby sevens, it's one of those sports that have really catapulted, the name of Kenya in the global arena. But that notwithstanding, you still went ahead and did what you did without giving them an opportunity to be heard. Now, the World Now organization, when it came later and did now a very comprehensive, the World Rugby Anti-Doping Advisory Committee member, Mr. Gregor Nicholson, came, took 2 years, did a thorough job, and it was found that you are actually wrong, essentially vindicating them. But you can imagine now they are being vindicated after a lot of damage has been done. So I don't know what you would say about that, because that seems now to contradict what you just said about being in this international organization where, and bodies where you've been able to actually do very well in terms of proving that you can be fair, you can be just, you can be equitable, and all that. And remember, now you'll be going to be the Chief Justice, where you're expected actually to be an embodiment of fairness, application of rules of natural justice. I don't know what you would say about that.
Yeah, thank you, Honorable Commissioner. At the time I took over, I was appointed to the task force. A total of 34 Kenyans had tested positive for banned substances, including a rugby player, a football player, and so on. That is well documented in Appendix 1 of the report, which was submitted by Mr. Kankla, which I also submitted. In carrying out our investigations, we took a three-pronged approach. Number one, we contracted researchers from Kenyatta University to carry out an empirical research. They went out to rugby, to players, not just rugby, we're dealing with all sports. they recruited 1,500 in their sample. They used a questionnaire. Out of that, 1,365 returned failed questionnaires, giving it a 93% return quota. Of the 1,365, 226 were rugby players. There was then the question put to them, do you know anybody who uses prohibited substances? 78 of them said yes. It's in chapter 3. Then we went further. The question went further. Do you know what they use? And the answer was about 75% said yes, they use steroids. We were brought that report. So, and there were reports about others also. So specific now to rugby, we were told, yes, they use prohibited substances, they use steroids. That was one track. The other track is we conducted interviews. Number one, we invited all Kenyans to come and make presentations. And a number of rugby coaches came and made their presentations. I have furnished the commission with the detailed daily reports. We wrote to the chairman of Kenya Rugby Union on 16th of December, asking him to come and explain to us several things, including policy issues. As we did that, their official, the one in charge of programs, had appeared before us on 4th of December and told us the things they do there, including giving some things to players. We asked him, have you people tested those things? He said no. Do you know the ingredients? They said no. Then at that point, we took some samples for testing. Now, the other coaches came and also gave their narrations about the goings-on in the sport of rugby. They are all documented per date and per name. Having received, when the results came from the lab, and this was a University of Nairobi specialized drug analysis laboratory, it marked that all the samples that we had put in had tested positive. On 4th of March, we then, I think 6th of March, we wrote to the chairman of Kenya Rugby asking him to come before us. He did not come, but graciously he sent a team of 3 officials who appeared on the 17th of March. These 3 officials, one of them was a board member, the other one was a team doctor, the third one was the person in charge of logistics. They appeared before the task force. We discussed rugby. We gave them the results from the lab. We showed them. They looked at them. They were totally shocked. The results from the laboratory showed that the samples of the products that were being used had tested positive for steroids. So then, after that, we agreed to now get all the samples and keep them away for fear that these were going to harm our young youthful players. So, at the point, up to that point, we had information from this empirical study of 226 rugby players. We had interviews with about 5 rugby coaches and officials who had given us information. We had this information from the laboratory, 3 different sources. We asked these officials, who is it that gives these things to our players? They gave us the names. We did not cook up those names from anywhere. So then in our recommendation, I think it's the last recommendation at page 37, we said these persons should be subjected to a disciplinary process.
Okay, let's now be, let's hold on there. The people that you named specifically, names, did you summon them to hear their side of the story? The people that you specifically named in your report. Forget about, you are saying that you are told so and so are the ones who are responsible for distributing those substances. Now, those names that you are given, assuming you are right on that, did you summon those people now before putting their names in the report to hear their side of the story?
Now, specifically about summoning them, we were unable. Reason is, around December, the teams were out in Los Angeles playing. When we wanted them, we were told they are out of the country. Come the new year, they were on some tour in the Asian Southeastern.
What were they doing those tours?
They were playing rugby.
For which country?
I'm talking about the Kenyan team plus the coaches.
National duty.
Yeah, they were on that international trail.
Yeah.
We were unable to get them. Yeah. Our time as a task force was running out. So we recommended that they be subjected to a disciplinary process. And Honorable Commissioner, let me also add here that in terms of due process and given our terms of reference, we were meant to identify any people we think have something to do with this bad image that was going on. Now, one can emphasize, allow me to finish. Okay. One can say they were on national duty. They had been on national duty all along, even when some of them tested positive. Track and field, they are always on national duty, but they test positive. And they out there, the world was complaining, you Kenyans, you are playing dirty.
You see, Prof, the point that I'm driving across, you'll be the Chief Justice there. You can imagine when you put on record somebody's name regarding an allegation, you know, you've already defamed them. You know the implications of that. And removing that record, that's a record that will always follow them. You know, so that's why, and it's basic rules of natural justice. But we are not here to review the case, that matter, you know, because that's not, you know, our jurisdiction, so to speak. But
no, Honorable Commissioner, this is a very sensitive matter. The rugby people are looking at this, and I think it's also good to give me some latitude in time. This, our task force report, was eventually given to the World Anti-Doping Organization. It went through it. Then we had identified 3 case studies: athletics, FIFA, and World Rugby. It gave to those people under paragraph 3 of the Nicholson report, which I furnished. The other commissioned by World Rugby says yes, they received this report on the 22nd of 22nd of October 2014 from the World Anti-Doping Agency with a request to follow up on the recommendations. Our main recommendation was subject them to a disciplinary process. From there, it was now up to World Rugby to verify whatever we had found and then see whether they need to be disciplined or not. And World Rugby did that.
In fact, you know, you just preempted what I was going to come to, that the World Rugby's specific focus was whether there was any evidence to suggest that an anti-doping rule violation had occurred. And on March 10th, 2016, 2 years after your report, the Nicholson Committee, this is now the World Rugby one, cleared Kenya Rugby of all allegations. Isn't it? They cleared them completely. But you see now, clearing them, yes, but you'd already condemned them and had. That's the point that I was trying to indicate, that 2 years later they are cleared. But you can imagine the anguish they go through, which is now why I'm worried that if you became now the Chief Justice, because it's a quality about drawing conclusions, rushing to judgment without giving an opportunity to somebody to be heard. That's the point that I'm trying to address. You know, considering that this is going to be a Chief Justice, Professor Moni Wekesa. That's my worry. But as a last point on this issue that we can close the matter. Now, at the time when you're doing those that research or investigations, now the only accredited WADA laboratory in Kenya, in Africa, was only one, isn't it? The only accredited laboratory, WADA accredited laboratory. Where was it?
At the Free University in Bloemfontein.
Exactly. Now, so the samples that you used, which laboratory did you send them to?
Yes, the laboratory we sent them to is marked as under Appendix 6 of the report.
Which laboratory?
This is the Drug Research and Analysis Laboratory of the University of Nairobi School of Pharmacy.
Now, you see,
I'm coming to that, Honorable Chair.
Yeah.
Sorry, Honorable Commissioner.
It's because the Chair has given us very specific time. That's why you can see I'm trying to rush you.
No, it's okay. I've seen in the complaint somebody mentioning that lab. At the time we asked that lab, they told us they don't deal with foods. I have now furnished the commission with a printout from the website which says the laboratory only handles urine and blood samples. So even at that time, that laboratory was not available. I consulted. We have an Africa representative for water based in Cape Town. I consulted him. We checked with that lab. It said it could not handle. So we used preliminary results, and I think it's also good to point out that at paragraph 16.24 of the Nicholson report, they say that yes, the task force relied on the results of the Daru lab. We do not condemn anybody unheard. We collected information from several sources. I have furnished invitation letters that went out to the chair of rugby. The complaint there is that we never invited rugby to appear. Rugby appeared in a very big way.
All right, thank you. That's all, Honorable Chair.
Thank you, Commissioner Macharia. Thank you, Professor. Commissioners, let us take a few minutes break. Good morning, Honorable Commissioners. Good morning, Professor. We are now ready to start the interviews. As commissioners, we have been made aware that there is a court order, but the court order does not stop us from going on with the interviews for today and tomorrow. So we will continue with the interviews as scheduled. And our candidate today is Professor Moni Wekesa. And we'll take 1 minute for the pictures and then we'll continue with the interviews. think that is enough. Once again, welcome Professor Wekesa to this interview. We want to thank you for availing yourself.
Thank you, Honorable Chair.
And we will start by introductions. My name is Professor Olive Mugenda, Commissioner representing the public, and I'm chairing these interviews. And to my right.
Good morning, Professor.
Good morning, Honorable.
Philomena Mbetemuilo. I'm the representative of the Supreme Court to the Judicial Service Commission. I'm also the Deputy Chief Justice of the Republic of Kenya.
Thank you very much, Honorable DCJ.
Good morning, Professor. My name is Pat Kishoi, representing Public Service. Karibu.
Thank you, Honorable Kishoi.
Good morning, Professor. My name is David Majanja, Judge of the High Court, representing the Kenya Magistrate and Judges Association.
Thank you, Honorable Majanja.
Good morning, Professor. My name is Oluwande Evelyn. I am a Chief Magistrate. I represent KMD.
Thank you, Commissioner Honorable Oluwande.
Good morning, Prof. My name is Machari Njero. I represent the Law Society of Kenya. Welcome.
Thank you, Honorable Njero.
Good morning, Professor. My name is Felix Koske. I represent the public.
Thank you, Honorable Koske.
Morning, Professor. My name is Mohammed Warsame, Judge of Appeal. Welcome.
Thank you, Honorable Sami.
Very good morning, Professor. Kehara Kariuki, the Attorney General, and on this panel by virtue of that office.
Thank you, Honorable AG.
Professor, we also have Honorable Anne Amadi, who is the Chief Registrar of the Judiciary and the Secretary to JSC.
Good morning, Professor.
Good morning, Honorable Amadi.
And we also have our Registrar JSC, Honorable Frida Mukaya.
Thank you, Honorable Mukam.
Professor, as we've been telling other candidates, if you have any problem with any question or you need clarification, you are free to ask the Commissioner. We are all going to ask you questions, the 9 commissioners, and after 2 hours we are going to have a short break, so you can also rest a bit. So and now we will start the interviews. Professor, and I will be the one to ask the first question. First of all, let me commend you for a very impressive CV. It's very detailed, and you have done a lot of work, Prof, and thank you for that hard work. I also note that in the 80s and 90s, you are in education, and I must confess that we are together teaching at Kenyatta University. In the 80s and 90s, particularly in sports education, and then in the 20s, you moved to law. Could you please tell the Commission that journey of transiting from education to law?
Thank you, Honorable Chair. My life started in a village called Namirama in Navaholo sub-county of Kakamega County. Went to Namirama Primary School, Musire High School, nicknamed Box 14, Chavakali High School, then University of Nairobi, where I obtained a first-class honors Bachelor of Education degree 1981, Masters in Sports Medicine and Rehabilitation, and PhD in the same from Cologne, 1986-89. Then came back to do service to the country. Honorable Chair, in the course of doing service to the country, I traveled with the national junior soccer team to Helsinki in 1992. One of the boys punched somebody there and he was arrested. Now, the coach and team manager said, Daktari, wewe ndio unaweza kuongea na hao watu. Sasa enda utusaidie kutoa mtu yetu. Honorable Chair, I felt totally handicapped. I thought I had attained. I thought I had read it all. Of course, I then went to the police. We had a long talk. They released our boy, and that ended it. But then at that moment, I started asking myself, what is this law, and what what authorities would Finland or authorities in Finland have over Kenyans? That's a question that started plaguing my mind. Come the following year, Honorable Chair, we traveled to Cairo with the with the senior team now. Normally, clearances are very easy at customs. The national team collect passports. They are stamped en masse. We went through. Getting to Cairo, we were received by the football officials just before the customs, collected the passports, stamped, we got in. Coming back, each person was required to have their own passport. Then it turned out that the team manager had taken a passport that belonged to a different player and attached it to a player who didn't have a passport. So he was arrested at customs. Then once again, the coach and team manager say, Daktari, wewe ndio naelewa hii maneno, tusaidie. I went to the customs officials, we had a chat, a long chat, but of course now at that point, my point was, here is the plane waiting. This person is going back to his home country. Why would you want him to sit here and live on your expenses? Kindly just allow us to go. We shall sort out this thing when we get home. He was eventually released. From then on, Honorable Chair, the seats of studying law were sold. So then I went to law school, graduated with a bachelor's degree in 2002, master's. When I went to do the bachelor's, my idea was to specialize in international law because of what I had experienced out there. But getting in, I found some more interesting areas like law, science, technology, and sports law. So I eventually diverted in that at the master's and PhD. Honorable Chair, have I answered the question?
Yes, I think you have, Professor. And I noticed that you use double doctor, so you call yourself Professor Dr. Moni Wekesa. Is that more of a German tradition, or is it your preference?
Honorable Chair, we have different academic cultures. Those people trained in the US, like the Honorable Chair, just write their names, Olive Mugenda, PhD. In the UK, just write Doctor so-and-so and it's done. In Central Europe, the culture is totally different, right? Professor, doctor. If you have 2 doctorates, professor, doctor, doctor. If you have 3, the same thing.
Okay, so it is a culture.
So it is a culture I picked up from one of my alma mater.
Okay.
And Honorable Chair, it is doing wonders here also because very many people have been encouraged. One came to see me in 2019. He said I had encouraged him. He had a PhD in entrepreneurship and a PhD in law.
Wow. Okay. Thank you very much for that. Professor, again, looking at your CV, I noted that you have held many leadership positions, chairman of department, dean, and different universities. So what leadership qualities do you possess, Professor, to make you a great CJ if we select you?
Honorable Chair, I am a transformative leader. With that, I mean, I'm a good communicator. I'm good at problem solving. Bring in a problem, I'll see how to sort it out. I listen to others. I engage with others. I pay attention to other people's views. I build teams. I bring out the best in others. I encourage others to offer their best. I'm consultative, collegial, and all that makes a good leader tick.
So what is your understanding of a transformative leader? Because, Professor, I think you can communicate well, you can listen, you can build teams, but you are still not able to transform. So what is a transformative leader?
Honorable Chair, a transformative leader is one who is able to look at a vision, get the team to buy into the vision, set specific objectives, motivate people to work towards achievement of those objectives, and where one may be lacking behind or for whatever reason, the person is encouraged to come along. It's a way, through this kind of leadership, one is able to carry everyone on board. One is able to encourage everyone to do their best. All through my leadership positions, I've always told people I've worked with that please tell me your strength. We cannot sit anywhere screaming about weaknesses. Tell me your strength. Let us build on your strength and see how together we can move this team forward, this organization forward, this schools forward, this department forward.
So, Prof, could you tell us practical examples or situations where you have transformed an institution or transformed a department or done something transformative, very practical example in the areas where you have been working?
Thank you very much, Honorable Chair. I started the School of Law at Mount Kenya, hiring staff, recruiting students, ensuring that the staff deliver so that the customer is happy, more getting that together so that we all move and speak from the same language. Honorable Chair, while at Mount Kenya School of Law, I decided we needed to get our students to start behaving like lawyers. So I had a chat with the student leadership, had a chat with them, and we introduced the wearing of suits. At Mount Kenya University School of Law, Monday, Tuesday, every student is in a suit. They like it very much, they look very responsible, they appreciate it, and that has taken root. And it's up and going. At Daystar University School of Law, now with a little hindsight, we made it Monday to Friday. So all law students look very smart. They look the part. They have chosen to be lawyers. They start that from day one, looking, behaving, thinking like lawyers. But allow me also to mention, Honorable Chair, that around 2012, we had a problem as a country in the area of sports. Our athletes were winning, our teams were playing and winning, but there was a dark cloud hanging over our athletes because of an animal called doping. Doping is the use of prohibited substances or a form of cheating in sports so that one wins, not because they are putting their own effort, but because they have taken some drugs. At about that time, Honorable Chair, over 30 Kenyans had tested positive and their names were being flagged on websites globally. So then we started getting bad publicity in the international press. The then Minister, Honorable Tuoma, tried to issue a press statement. He didn't help. Pressure started coming in, especially from the World Anti-Doping Agency, and the thinking in the international circles was, if these Kenyans are winning through cheating, we just lock them out, let them compete amongst themselves. But then for a sports person, competition only makes sense if it's international, and it's from the international competitions that they're able to make money. So then there was that threat. Coming after elections 2012, a new cabinet secretary comes in and he says, let's get to the bottom of this. So I was appointed to chair a task force on to investigate matters of anti-doping in 2013. At the time of appointment, I was doing something at the Université Libre de Kigali. So I just got news of that while there, came back. I found a wonderful team of 12 people I had never worked with before. 5 lawyers, 2 medical doctors, one from Nakuru, another one from Mombasa, sports officials, and from the AG's office, from the ODPP, from the sports ministry, from everywhere. 12 of us. After the first 2 meetings, Honorable Chair, we gelled. We worked on focusing on the objectives. We worked on the objectives, produced a report. The report was received by the government. It was very well received by the international community. The government acted on it, And as we sit here, Honorable Chair, we have an anti-doping law in place. We have an anti-doping agency in place. The international community is no longer doubting our sports persons.
Okay, thank you for those examples, Professor. I'm just thinking about the rule for students to wear suits Monday to Friday. And I'm just wondering whether, when you think of a university student, you're thinking of blue jeans and t-shirts. I mean, that's the life of a student. Now, if they are wearing suits, and nothing wrong with that, but have you considered those who may not be able to afford the suit Monday to Friday? Have you taken care of them?
Oh, yes. Honorable Chair, that question came up in our discussions, especially at Mount Kenya. And it was in that light that the students said, okay, sir, we think the idea is very good, but then some of us may not be able to afford 5 suits at a go, meaning if I have one suit and I'm wearing it 5 times a week, after 1 month, it will no longer look like a good suit. So kindly allow us to implement this in a progressive manner. So we said, okay, how do we do it? Then they suggested, we were discussing like in this semester to start the following semester. They suggested, well, for the following semester, let us make it 1 day in a week. So we said, okay, Monday. The semester thereafter, we make it Monday and Tuesday. It's of the judiciary to desist from corrupt practices. And this is because if there is corruption in the judiciary, there must be somebody else out there who is bringing it to the judiciary. We should be able to deal with that. And in this respect, I'm happy and glad that the Honorable Attorney General chairs the multi-agency team that is tasked with that. And that would be a good point at which, as CJ, I would want to kind of also get in and try to help make an impact. The third one is automation. Automation, in a way, cuts out lots of other things that could be avenues for corruption. So increasing automation, that would help combat that. But most drastically, Honorable Attorney General, when I hear the word corruption, I'm not sure whether we are serious about fighting corruption. I have never given a bribe. I don't give bribes. In this respect, I have been arrested several times on the highway, taken for traffic overspeeding, traffic offenses. I have been kept in holding cells, Kibera low courts, Naivasha low courts, Eldoret low courts, and this is because I choose to subject myself to the legal process. Having gone through that a number of times, Honorable Attorney General, in 2015, I designed something I thought could help us Kenyans, help the government, help everybody. I call it the Digital Traffic Court. With this Digital Traffic Court, which is app-based, all the traffic officer needs to do is walk down a motor vehicle, ask for the details of the driver, key them in the system. The offenses, traffic offenses are already inbuilt, plus the penalties. Click on that. The driver pays for the offense. The money should be going to a central place in the judiciary or wherever it's supposed to go. And the driver is let to go. 5 to 9 minutes, a driver is cleared from the road. The experience I've had on the road is one of taking about 2 hours. First of all, to wait by the roadside, go to the police station, and then pay the cash bail before one is, and then after that, I then go through the motions of attending mentions and hearings until my matters are decided. Still arising from my experience at 2 boards of parastatus, the reports we used to get from the internal auditors were chilling in terms of leakages, pilferages in the system. I asked myself a question: isn't there a different way we can do this?
Having asked myself that, I answered it by designing an anonymous digital reporting system that can enable a person to report something that is in the pipeline going on, or to report anything that violates the code of conduct. Give all the details by way of attachments, and voila, the managers will be able to have a report. And to me, that way, we can be able to arrest this animal we call corruption before it takes off, and in the long term also reduce the number of cases that end up in the anti-corruption court.
Thank you very much, Professor. Let's move on to another area. You may be aware that the Chief Justice convenes the Judges' Colloquium on an annual basis. And were you to become the Honorable the Chief Justice, what would inform the agenda for your first colloquium with the Honorable Judges? And secondly, what items would be on that agenda and why? What critical items would be on that agenda and why?
Honorable AG, I would be preposterous to sit here and assume that I can already determine the agenda. What I will do is call the various heads, that is through the Judiciary Leadership Advisory Committee, discuss what has been dealt with in the past, inquire of them what they think we should put on the agenda. From there, then maybe I could also suggest one or two things. But I don't look at my management of the judiciary as a one-man show. But then more specifically, we have some ongoing problems. Problems to do with digitization, problems to do with delays in writing judgments, challenges to do with refunds of monies paid in. There is still a court station from which I haven't yet received my refund for cash bail I had paid in. And I'm not saying anything, but I'm patient to wait because it's part of the process. But then I think many Kenyans would be happy to have something that moves pretty fast. And this is one area that I would want that to come out. And then also we need to be discussing even this thing that's very close to my heart, where each judge writes their own judgment. It's one thing to say it, but it's also good to give colleagues an opportunity to ventilate, be able to buy in and move along with it.
Would you see the Judges' Colloquium as an opportunity for you to enhance judicial accountability and independence and collegiality?
Your Honor, I would see it that way, and I think that's one of the purposes. Am I supposed to continue?
Yes, please. How would you, as Chief Justice, use that organ?
In terms of collegiality, Honorable Attorney General, this forum provides an opportunity for colleagues to mingle, talk, discuss, socialize with each other. That is one of the ways of enhancing collegiality. This colloquium provides an opportunity for discussion of emerging areas of law, and that would also be an opportunity to kind of help improve competences. You asked specifically about independence of the judiciary. This colloquium is an opportunity it would be an opportunity for us to keep reminding ourselves of the duty we owe to the Constitution end to the law in terms of individual decision making. And also, of course, be able to discuss other things that can be done in order to protect that independence.
Thank you. Now, you've been a teacher of law for a number of years now. How would you use the Judiciary Training Institute to revitalize the continuing professional development of judges and magistrates and colleagues?
Yes, Honorable Attorney General, with respect to the Judiciary Training Institute, one of the things that I would want to see in place is a defined, say, curriculum or work laid out for a particular year. So if we are looking at, say, 2021, 2022, then we should be able to agree or set out the agenda for training for that year. In terms of the training itself, develop guidelines, develop materials to help staff, to help judicial officers who will be attending that. But then, Honorable AG, I still have another view, namely that the Judicial Training Institute, together with the Education Committee of JSI, should be able to map out something that can help some linkage with civil society, some kind of education package, a kind of message that the JSC, the judiciary, wants to be given out to the people about the judiciary. So I would want to see a more expanded role of the JTI.
Thank you, Professor. And finally, earlier you mentioned that you were engaged in establishing the law school at Mount Kenya, and you were engaged in the recruitment of faculty and students. What should the judiciary do to attract the best and the brightest, and what should it do to retain them?
Thank you. Number one, in terms of attracting, the judiciary needs to set benchmarks. At the moment, I know of some law schools that say if one did not obtain at least an upper second-class honors degree, even if one has a PhD, one is not eligible to teach there. It's one such a law school. So then if the judiciary wants to attract what the Honorable Ichi calls the best, I think it would be a question, number one, set the benchmarks. What are the qualities we want? What are the minimum standards? And then that one, recruit. In terms of retention, that is where the challenge lies. As Chief Justice, I will do a number of things to ensure that this happens. Number one, I already talked about availing scholarships to judiciary staff. I would want them to enhance their competences. I would want them to grow. I would want them to advance. Number two, improving the working conditions. We need to have conditions where everyone feels appreciated, where everyone feels at home, where everyone feels comfortable, where everyone's opinion counts. If we're able to create such an amiable working environment, we should be able to retain quite a number. But then again, of course, you can see from my CV, I have moved around a lot. We could still have staff who equally wish to move around a lot. I would want us to empower them, give them wings to fly. I think I would be very happy as Chief Justice to hear that this principal magistrate who was based in Migori is now the principal legal officer at a UN office in Geneva. As Chief Justice, I would be happy to know that this judge so-and-so previously based in Malindi is now at the ICC. I would want to give opportunities to staff to realize their potential, actualize, grow as much as they can, to kind of just, so that's the kind of where, those are some of the ways I think of retaining. Of course, that is the minor thing. Everyone talks about, oh, pay. I want to say it here and now. I have worked in many organizations. Pay is nothing. It is actually what the service one wants to render there. So, yes, maybe at some point one will want to angle for pay, one will want to do one, but I just said we make the working conditions comfortable so that the output also meets the judiciary's expectations.
I am grateful to you, Professor, for having answered those questions. Madam Chair, that would be all from me. Thank you.
Thank you very much, AG. Commissioner Gishohi, it's your turn to ask questions.
Thank you, Professor. Professor, good afternoon.
Good afternoon, Honorable Commissioner Gishohi.
Thank you, Professor. I want us to focus on something different, and I want to focus specifically to your role as a chairperson of the Commission. That role as a chairperson of the Commission, we have programs, strategies that have been initiated from 2011 to 2016, 2016 to 2021. The challenge moving forward is implementation, in my view. Could you share with the Commission one thing that you do to expedite the implementation of those issues that we have from 2011, 2016 up to 2021 in terms of transformation of the judiciary? Implementation, just one.
The one thing I would really put my thumb on and really insist on is digitization. ICT.
Mm-hmm.
I said at the moment I enjoy getting into an international courtroom with people from different parts of the world meeting in one space. I would want us to enhance ICT, not only in the judiciary, but also in the other supporting organs of government, such as the ODPP, the prisons, and so on, so that we kind of move together, and then we are able to render service to the people of Kenya appropriately.
Okay. Let's move on to, in terms of coordination. You are the chairperson of the Commission. I want to hear from you, in terms of the coordination, how will you ensure effective coordination in the Commission, both at policy level and at the operation level, management level? How? In terms of coordination.
Yes, in terms of coordination, say at the policy level, I would want the Commission, I would want the committees of the Commission to be very effective, so that these ones work on specific thematic areas, say like finance, audit, education, governance, and so on, and bring reports at the bigger meeting of the entire Commission. That is by way of coordination. Now, in terms of the second part was
management.
In terms of management, just to ensure that the officers tasked with their specific tasks are able to respond within the given timelines.
Okay, Professor. I'm sure you have looked at the literature that we have, and I hope that maybe in your understanding and also your experience, have you been able to see any areas of weakness that you can strengthen in terms of those operations, in terms of the policy, and also at the management level, if you become the chairperson of the Commission?
Yeah, thank you, Commissioner. In terms of management, I think I have looked at the proposed restructuring, and I would say we give it a chance. In terms of operations, Honorable Commissioner, this commission is not known to the people. The commission has not been able to communicate to the people effectively. So one of the things I would want to do is, as a commission, we agree to bring on board musicians. Let them, musicians, singers, let them compose songs about the judiciary. Let them compose songs about delayed judgments. Let them compose songs about disobedience of court orders. Let them compose, and in very many languages, so that those using public vehicles will be listening, and one of the songs will be on the judiciary. Those doing whatever will hear about.
What kind of songs?
I said songs about the judiciary. You know, songs carrying the message of the judiciary, about the judiciary, how to approach the judiciary, what the judiciary does, and so on. Now, I'm still on publicity. The Public Affairs and Communication Unit, I would upgrade it to a directorate, so that then we also have a judiciary spokesperson. This, to me, would be the person who will be giving press conferences, who will be communicating with media houses on the goings on in the judiciary.
In your view, Professor, who would be the spokesperson of judiciary, official spokesperson of judiciary?
Official spokesperson is the CJ, but I'm just saying we have an officer who will be doing the hands-on thing.
Okay.
Yes.
Now, I want us to look at Article 232 of the Constitution on principles and values of public service that guide all state organs, including judiciary. I've picked 3 of those values and principles. 1, effective, efficient, and economic use of resources. 2, accountability for administrative acts. And finally, fair competition and merit as the basis of appointment and promotion. If you could just be able to tell us how you would promote, just one way or strategy that you'd be able to promote each one of those 3 values, starting with the first one.
In terms of efficient and economic use of resources, to enhance our accountability systems.
Accountability systems.
Many organizations are pleading because, say, money is given out in the form of interests. It takes too long to be accounted for.
Professor, sorry to interrupt. I want you to focus in the commission, judiciary. You are the chairperson. That is one value that you're supposed to ensure that you promote. And when you're discussing that, look at it at the wider aspect in terms of the framework of that accountability.
Yeah, okay. Looking at it from, say, the JSC side, I would say there's need to put in place policies. Policies that speak to specific resources. Policies that are to be implemented by the JSC and maybe elsewhere. But then here we should be able to look at what we have by way of resources and see evaluate whether we are putting them to the best use. Where there are issues, where there are problems, we address them.
Okay.
That is on use of resources. Accountability
for administrative acts.
Accountability for administrative acts, Honorable Commissioner, I would say so far the Commission has done very well by advertising, indicating shortlisted candidates and televising interviews and so on. It's a way of accounting for administrative acts. However, there will be other actions that cannot be so publicized. But still the Commission should be able to say, we took this decision because of A, B, C, D. One must be able to give reasons. And I think that is a major dictate that runs through the entire Constitution, not only Article 232. With respect to fair competition.
Before you go to fair competition, in terms of sanctions under that particular article, that value.
Accountability. That is a very touchy area, Honorable Commissioner, the one of sanctions. Yes, where one is kind of failing in their duties, then it becomes necessary to effect some sanctions. However, as Chief Justice, I would want to have some committees in place. I would want to have some kind of intervening fora that where we have challenges with accountability, especially of officers, they be talked to first to understand their side, to appreciate their own challenges before we talk of serious sanctions. However, of course, again, the Commission has an obligation to deal with errant judicial officers. That one, again, the Commission cannot run away from it. So that is part of it, but I would just say that I would want to approach this whole thing with a humane face.
Okay. Move on to the next one. Fair competition.
Fair competition and merit. This is also something that runs through the, especially at Article 10 of the Constitution, and of course coupled with Article 232. And here again, it would be good to look at it would be good to put certain, I would call them certain measures in place. Are they measures or benchmarks against which we can then measure fairness, against which we can talk of merit? And however, even in terms of talking of fair competition and merit, there will be other things too that come into play in line with the Constitution. So indeed, yes, it's, I would want to see the Commission being fair, having a fair competition, talking considering merit, plus so many other things.
Those are the other things I'm looking for. What are they?
In terms of fair competition and merit, this brings in the question of differentiation and discrimination.
Yes.
And this just, excuse me, this just means that we have other, what I'm calling those other considerations, like age, gender, ethnicity, county of origin.
Okay, Professor, all those
and whether one is disabled or not.
Okay, all those policies are there. The question is, make them realize their goals. As we sit here this afternoon, those policies are there in the Commission. And I'm saying, you, as a chairperson of the Commission, one of your responsibilities and duties is to realize those values. My interest is, how would you ensure that those values are not only in book, but they are actually realized and Kenyans enjoy them?
Honorable Commissioner, this is something I can say I have hands-on experience from other organizations. What we do is, in terms of promotion, we let people apply, look at what they are putting on the table, and pick according to merit.
Okay. In terms of strategic partnership of the Commission, could you share with us your appreciation of that statement? Who are your strategic partnership as a chairperson of the Commission? 3 of them.
Honorable Commissioner, that is extremely limiting, but
just 3.
Let me mention your former employer, Parliament, as one of them.
Specific in the Parliament?
Specific in Parliament, there are committees that deal with finance, there are committees that deal with legal affairs. But in my earlier presentation, you heard me say that we need to go beyond those ones because all those members represent people.
Fine. Let's go to the other one. Parliament accepted.
The second one is the executive.
Executive, yes.
And under executive, I have in mind the treasury and the executive office of the president.
Okay. The last one?
The last strategic partner, the people of Kenya.
Very good.
We need to carry them on board.
Sure. Thank you, Chair. Thank you, Professor. Thank you.
Thank you very much, Commissioner Shohi. Thank you, Professor. It's now the turn of Commissioner Koskei to ask his questions.
Thank you, Chair. Good afternoon, Professor.
Good afternoon, Honorable Commissioner.
Yes, since morning we've been talking about the past and the present. The past in terms of what you've done, your academic background, the experiences, and the present situation in judiciary. I want us to go forward. I want you to perhaps give us minimum of 3 challenges that you are foreseeing that judiciary will face within 5 years and in the delivery of its services. And how would you deal with them? 3 challenges that you are foreseeing that judiciary is likely to face, and give us solutions to those challenges. Because we, God willing, will be ushering in your administration.
Yeah, thank you, Honorable Commissioner. One challenge that is and appears to be persisting is the one of interdependence of the 3 arms of government. We are emphasizing independence, and that is in order. But then I'm reminded of the words of the South African Constitutional Court in the case of, in the matter of the Constitution of South Africa 1996, in which that court said the 3 arms of the separation of powers is indeed a good thing, but that separation cannot be complete separation. There is some element of partiality, partial separation, which brings in the idea of interdependence. So yes, let the judiciary work independently, let the JSC work independently, but we must find some common ground of interdependence with the other arms. And to me, this is where I was saying, we just go full blast out, engage all those members of Parliament, engage as many members of the executive as possible, not restricted to the Treasury and the executive office.
Yes.
Just engage in order to kind of bridge that gap. But again, there is the warning that in such an engagement, the independence of the judiciary should not be sacrificed. So yes, I'm looking then at a structured engagement with the other arms of government.
That is one. Number 2?
Number 2 touches on resources, finance. We rely on the exchequer, we contribute to the exchequer, but there are other competing interests. For example, now when something abruptly pops in like COVID-19, priorities have to be realigned. However, with respect to the judiciary, two things. Number one, ring-fence the judiciary fund,
Yes.
just to make sure that the funds allocated to the judiciary are not diverted elsewhere to the point of disadvantaging the programs of the judiciary. Then number two, on the same, network with what are called development partners. There could be a partner like UNDP that is interested in sponsoring judicial officers for short visits to other jurisdictions in the country. There could be others that have the capacity to spread the message of the judiciary to the villages around. We need to be able to network with such partners, and they will be doing it using their own finances. That's why I'm putting it under finance. So that will not be a cost to the judiciary, but more or less an additional support to the judiciary.
Yes, well said. Number three.
Number three, Honorable Commissioner, this is very close to my heart. Public awareness. And let me allow me 2-3 minutes to explain why it is very close to my heart. It pains me when judicial officers make orders which are disobeyed. It pains me to see courts I respect so much give orders which are trashed. I fear for what could happen if that kind of trend continued forever. That is a state of anarchy. For us to be able to contribute to the obeisance of court orders, I propose, sorry, I would propose public awareness so that we build allies of the judiciary, pressure groups. Let us talk to the trade unions, explain to them how the judiciary works, the importance of obeying court orders, and whatever. Then that way, if one of the unions wants to disobey a court order, the others will pressure that one to obey. I'm thinking about...
Well said, well said. Thank you. We have gotten the solution, and we are happy about that. Now, going back to your answers to several commissioners' questions, you've been talking about automation. And I've seen in your CV somewhere under the title innovative, I think it was innovation.
Innovation, yes.
Innovation. And you seem to be a very good solution giver. When you are faced with a challenge, you quickly think of a solution. And it's a good thing. Right direction, especially when you are giving solutions that are on, that are ICT based. I wanted to ask this question, and from your experience and borrowing from your past interactions and situations that you have thought of, giving solutions. What are the areas in judiciary that you think you will quickly come up with digital solutions that will, help the consumers of justice in this country to access and to get it quickly, as fast as possible, as you had explained earlier? Which areas? And as you're answering that, have you thought of using blockchain technology to solve challenges of register management and these other many many issues surrounding filing and other areas of operations of judiciary.
Yeah, thank you, Honorable Commissioner. One of the areas I can quickly mention is that of judgments. I want to see a situation where after judgment is delivered, it is available. Something interesting happened, it's one of the things we discussed earlier, the report from the World Rugby. World Rugby called me at 10 a.m. to inform me that they were going to release that report. That was on 10th of February 2016, and they said they were going to release it at 4 Kenya time. I asked at that point, whether I could get a copy so that by the time they are releasing, I'd have gone through it. The gentleman said no, but at 4 o'clock, at the time we are talking about it, we'll release it. Come 4 p.m., I was able to see it. So, judgments. We have a situation where, because of maybe constraints here and there, a decision is made, then it takes another 2, 3, 4 weeks before one can get the judgment. I would want us to digitize in such a way that as the decision, or as soon as the judicial officer finishes reading and signs, it goes in the air. One is able to access it. And I think consumers will be very happy with that. The other area in the judiciary that we think consumers can benefit from in terms of ICT is the matter of virtual hearings. At the moment, I have felt very happy to sit in my house and attend to a court matter in Busia. That is very good. However, this technology is not yet widespread. That is number one. Then number two, there's still a general challenge with interconnectivity of the internet. So as then we think of enhancing virtual courts, that's the word, we need to then be working with other arms of government to see how to improve connectivity and even electricity supply. So virtual courts, for me, would be another area that we need to strengthen so that, again, we don't have people spending bus fare, money on transport, traveling, you know. It has those advantages.
Yes.
The third area, Honorable Commissioner, is in internal management.
Yes.
We should have a system internally whereby if an officer applies for leave, which can be done online, that is all. It should be received somewhere, actioned until the officer receives feedback.
Yes.
Same to finance management, where somebody is applying for whatever it is, one should be able to put in the request online, and with the press of the button send, that already calls for action from the other responsible officers until the requesting officer has what he or she requested for, or if there are reasons for denial, the same are communicated timelessly. Then the Honorable Commissioner asked about blockchain. And I want to say yes. In the anonymous digital reporting system that I designed, that is the concept. Allow me to say that through that concept, there's no room for erasure, and with respect to what I'm talking about, there's no way of knowing who sent a complaint, from where it came from, or from which device it was sent. Completely anonymous. It helps in solving certain issues, helps solving certain matters, helps freeing people to communicate what they wish to communicate without the fear of reprisals. So, blockchain technology, yes, it is with us, and it is the way to go.
Thank you. You adequately answered. My third question is on the same. You responded to one of the commissioner's questions that you want to take judiciary out. You want to engage from border people, Kenya Association of Manufacturers. So I really wanted to focus on the investors and investment and businessmen. And there is a clamor out there that we want a Chief Justice who has some kind of business philosophy, who understands what the country needs in terms of investment, who understands how employment is generated. And there is one writer on an article of last week, Nganga Mbogo, who said, although Nairobi has been positioning itself as a business hub and gateway to East Africa, to East and Central Africa, for global companies seeking to make an entry into the regional market, it does not match this narrative with a commitment to improve its judicial systems to provide for speedy and just resolution of business disputes and enforcement of contracts. Now, you are coming in as Chief Justice Moni Wekesa, and that is the clamor out there. That is what Kenya Association of Manufacturers are saying. That is what investors from all over the world are saying, that Kenya is good when it comes to climate. Kenya is good. Almost now the executive has improved their side, but the greatest problem now is judiciary. You are coming in as a Chief Justice. How will you fit the bill in as far as the requirement is concerned, and what is this that you are going to do to ensure that this country will be a destination of choice when it comes to investment and business?
Thank you, Honorable Commissioner. How I fit is that I am a keen listener. I pay attention to what others are saying. I am able to listen to problems and try to map out solutions. Now, specific to the business community, one of the things that I would want to see is a speedy rollout of the small claims courts. If we're able to do that, then a lot of small claims will be addressed very fast, and that will leave the court with bigger claims but with less workload, and meaning therefore that one is then able to address, give it the attention, give such a disputes the attention they deserve. That is one. And then number two, in terms of case management in the commercial courts. And sometimes when we say commercial courts, we only think of Nairobi. There are other commercial matters being handled out there. But with respect to commercial matters, I would want to see a situation where we kind of agree on some timeline for their completion, so that we are able to give investors the assurance that should a dispute arise which reaches the courts, then it can be resolved within a certain timeline in the first instance. Now, when it comes to appeals, we can then again work out other ways. Number three, the mechanism of arbitration. I would want to strengthen the mechanism of arbitration. Arbitration at the moment is kind of being managed outside of the judiciary, but we have other alternative dispute mechanisms like mediation.
Yes.
If we can bring mediation up to speed to deal with some of those commercial disputes, I think we'll be able to address the needs of the business community.
Thank you very much. My final question is just a comment. When I was going through your writings or the papers that you have published, you seem to focus, about 3 or 4 papers you published on music therapy. Music therapy among the Akamba, the use of music therapy by the Kikuyu of Kenya, and I think even the Keyo. What is music therapy, and what interest do you have in this music that helps other people? I don't know what it is all about. I really want to understand.
Honorable Commissioner, it's good that you ask, and this is because music generally changes our mood. Music helps the body generate certain hormones called dopamines in the body, which eventually give us a feeling of goodness. So when we listen to music that appeals and appeases us, we feel good, our mood changes, we are able to improve and even work more productively. Specifically among the Akamba, the Kikuyu, and the Keyo that we did, that was in the 90s, we did find out that actually music is used in certain instances to attend music therapy is given to people with short attention spans, and in the process they kind of get to improve and move on with life at the pace of the other people. Then of course music in some communities is used to exhaust, is that the right word? Exhaust evil spirits, as it were. So in those publications, we're just exploring the various uses of music therapy in different communities.
Thank you. As I'm closing, I have checked your CV again, and you're a person that involves himself much more than the others on community service. And I've seen several. Wherever you go, when you are in Botswana, Namibia, Kenya, everywhere, you have to do something to the community that you are in. I wanted to understand, what is your philosophy on public involvement, on giving your time to the community, your resources? What drives you to do that?
Honorable Commissioner, our life here on earth is very short, and I believe that we do well to use it to serve others. It is in this respect that you will notice that excuse me, I am a Sunday school teacher, something I have done since I was in Form 5 in 1976, and I do it consistently in whichever country I'm living in. You will notice that while in Kenya, let me highlight Special Olympics. These are children with mental disabilities. These are children that many people don't want to introduce to visitors when they visit a home and so on. We have special schools for them, and it's like, let them just sit there. So I volunteered for Special Olympics Kenya, and in that we were able to bring out the best in these children. I was with them when they represented Kenya in Minneapolis 1991, in the Yale area 1995, and in North Carolina in 1999. And I personally get thrilled when I see a smile on these children whom no one under normal circumstances would want to give a second thought. And for our own information, these are children that cannot fit in a normal school.
Okay.
And you've seen, even in Botswana, I did the same, Namibia the same.
Thank you very much, Professor. Thank you, Chair.
Thank you very much, Commissioner Koskei. Before we go to our last set of questions from Commissioner Orwande, Professor, you know we are bound by the Constitution to take into account diversity. So I want to ask you to tell us your county and ethnicity.
Thank you, Honorable Chair. I come from the county of Kakamega, and for the avoidance of doubt, I add there the sub-county of Navaholo, Maluya.
Thank you, Prof. And just one more question. I saw in your CV about honorary legal counsel. I think in two places, I think Kaimosi and another place. What is it?
Honorary legal counsel, this means I volunteer my services as a lawyer. I did that to Kaimosi University when it was starting, and to the East African University Sports Association. All these universities have a sports association, and they got me on board as their legal advisor.
Okay. So it's a title that is known.
Yeah.
Okay. Thank you very much. Now is the time for Commissioner Evelyn Orwande to ask you questions.
Good afternoon, Professor.
Good afternoon, Honorable Commissioner.
Before I move on to ask you the questions that I have, I just want to clear the air about certain things that you said earlier. To start with, there is that incident you narrated to us about the gentleman who switched passports, if I understood you correctly.
Who did what?
Who switched passports of some players.
Yes.
Yes. I wanted to ask, so how did that incident end?
I talked to the customs officials in Cairo. They had arrested our player. The plane was waiting. So I told them, now look at the circumstances. This person you are arresting is about to board a plane to go back to his home. You want to keep him here in your facilities at your taxpayers' expenses. Kindly forgive him, let him move. And he was released.
So it is the player who was arrested, not the person who switched the passports?
No. In terms of moving out, it was each person holding their passport. So the officials were able to detect that this passport does not belong to the one claiming, one presenting it. It's a player that was arrested.
It was an unfortunate mistake, or it was by design?
Now, in the first place, I got shocked that happened, because then we were in the clearing hall. But now, later on, when things settled, we asked the team manager why he did that. And he said, well, we were in camp, some players got injured, whose passports I had and I'm still holding. This one we had brought him in, he's a good player, but there was no time to apply for a passport. That is why I did that. So it was a deliberate action by the team manager.
The reason I'm asking this is because it seems to me that was a very serious offense that you downplayed, if I understood you correctly, on the promise that you were going to follow it up in our country. What happened when you got here?
Now, Honorable Commissioner, I did not talk about following up. I just told and explained and pleaded with the customs officials that this player is about to leave your territory. Kindly let him go. Offense, yes, that's why he was arrested.
Now, in retrospect, Professor, do you think what you did was the right thing? Ethically, do you think it was the right thing to do?
Let's look at it morally. Morally, we were in this difficult situation of leaving one player in Cairo, coming back the rest of us. he would then be subjected to the judicial system in Cairo, arrested, released after a number of years. What would that have done to that player? Now, let me also set the record straight that I was shocked at that act, totally surprised. I was not a lawyer then. I didn't even understand how the whole thing works. My only duty was to attempt to see if this player can be released so that he goes home. And I think I said the same about the player who punched somebody in Finland.
I was coming to that too. Still the same principle. What I'm wondering is, do you now in retrospect feel that the role you played maybe was not the best way to deal with the matter? Remember, we do have a court at the airport, the JKIA airport, that deals with people in transit. I don't think the fact that you're about to board a plane should be justification for circumventing the cause of justice.
Honorable Commissioner, with respect to the passport saga, I also said that usually when the Kenya national team is traveling out of the country, at the point of customs, passports are collected and stamped en masse. I didn't know there was an issue. Arriving in Cairo, the Cairo officials met us a few meters before the customs desk, collected the passports, stamped them, let us all in. It was now on coming back that the Cairo officials noticed that mistake. Arriving in Nairobi, nobody checks those things.
Okay, let me leave that at that, Professor. Another statement you made that caused me a little bit of concern is when you are talking about how you came about inventing, I think, some system that is supposed to facilitate quick resolution of traffic transgressions. You mentioned that you've been arrested severally. And I think Kenyans would want a CJ, a Chief Justice, who's a law-abiding citizen. I just want to give you this opportunity to clear the air around that, because the impression I'm getting where I'm seated is that we'll be having a Chief Justice who every other day will be getting arrested for traffic offenses.
Thank you, Honorable Chair. I don't get arrested every other day. The instances I have mentioned, Kibera, Naivasha, Eldoret, those span about 5 years. It's not like every week I'm overspeeding on the highway. Now, with respect to speed, sometimes when you are approaching a hill, especially going downhill, you may think you are doing this and it's possible to exceed by a few kilometers. Now, having done that and having my attention having been drawn to that mistake, I then subject myself to the due process of the law. That's why I said I go to the police, pay my cash bill, appear in court as required, go through the court process until the matter is resolved. And I think as Chief Justice, I'll be leading by example. I want Kenyans to stop paying bribes on the highway. I want them to submit to due process, even in traffic offenses, and be able to promote the rule of law.
Thank you, Professor. Okay, moving on to the question that I had for you. It is said that the law of succession makes no distinction between a male and a female child when it comes to inheritance. But it is yet the most discriminatory law against women. Do you agree with me? And if you do, why?
You have mentioned the law of succession in two limbs. Number one, that it quotes equal treatment in case of children to both male and female, but that it does discriminate against women. Yes. Yeah, thank you for your patience. with respect to children, as the law stands now, very favorable to all children. And let me also use this opportunity to inform our people that, you know, if you have a child, it's a child, whether girl, boy, that is your child. When it comes to sharing property, please share your property out equally. I'm not saying in equal measure, but don't leave out any child on account of his or her gender. That's number one. Number two, there's a lot of work to be done, especially at the level of the apex court, in setting direction with respect to inheritance law touching on women. And this comes from the history, namely that when a person gets married, especially of the female gender, she leaves her home to go and live at the man's home. Probably on that in traditional property and so on. All along, this person is seen as a visitor, as a stranger. That full acceptance has not yet dawned on our people. Now, in certain decisions, yes, they've been allowed to inherit, but I think this is one area where the Supreme Court needs to come out very authoritatively to set the record straight and therefore help us align our lives to that law, to the law that is not discriminatory.
I'm not sure I understand your response, Professor. Are you saying then that married women are not allowed under the law of succession to inherit the husband's property, or what exactly are you saying?
I am saying that inheritance of a husband's property goes on more outside than what we meet in the courtrooms. Away from the courtrooms, there are those traditional things that normally apply, traditional rules. With respect to the court, so far, the current emerging jurisprudence is that they are allowed to inherit. I'm also referring to the common practice traditionally out there for matters that don't reach the courts.
Thank you, Professor. But my question is limited to the Law of Succession Act, not case law, not traditional law. The Law of Succession Act, it is said to be discriminatory against women. Do you agree with me on that?
At this particular time, unless Her Honor draws my attention to a specific provision, I would be reluctant to do either.
Section 35?
I don't remember what it provides.
I thought you asked me to draw your attention to the specific provision. Because if I give you that, then I might as well just give you the answer.
Your Honor, I don't remember.
Okay, now that you asked me to give you the provision, basically that section provides that a married woman, when the spouse, or rather spouses generally, when one spouse dies, the other spouse is entitled to the household and personal effects, as well as a life interest in the residue of the estate. But for a married woman whose husband has died, that life interest terminates upon her remarriage. The same provision is not applicable to a man. That's why we say it is discriminatory. Okay, moving on to my next question. The criminal procedural law has gone through quite a bit of development over the last decade. I want you to just point out one significant development, especially in respect to the victims of crime, that has taken place in the last decade.
Indeed, the law has undergone a lot of transformation. With respect to the victims of crime, I don't have anything. With respect to the victims of crime, there was a change in which they could kind of get some compensation alongside at the time a decision is being made. I don't remember.
I'm talking about procedural, Prof.
Oh, procedural. In terms of procedure, a victim of the crime previously could not be represented by an advocate. Now it is possible for such a person to come with their own advocate to work with the DPP.
To participate in the trial.
To participate.
Thank you. My next question is a hypothetical question. I want to just give you a scenario and then hear your views concerning that scenario. In this era of COVID-19, cases of domestic violence have been on the rise. You are newly appointed Chief Justice, and the women in, remind me again, you said Navakholo? Navakholo. The women in Navakholo have decided to come together to start a self-help group or a CBO that helps the victims of domestic violence to find legal redress. So they approach you as a son from their village or from their sub-county, who has recently been appointed Chief Justice, to be their guest of honor in a fundraising so that they can help, they can set up an office and begin operations to help the victims of domestic violence in that manner. What would you do?
I will not participate, Your Honor, I will not participate in the fundraising.
Why is that?
This is because as a Chief Justice, being also a judicial officer, I'm supposed and expected to keep some distance from other members of the society.
Are we saying
that is one, and then two, I would not want to appear to be promoting one side, because if there is a complaint, the complaint involves two people. In terms of adjudication, it is good to hear both sides before arriving at a decision. I would not want anyone to approach the courts with a fear that the Chief Justice is already siding with the other side.
In this case, the self-help group.
Yeah.
Is there legislation or a framework that provides that you can't do that?
We have one, I roughly remember, that is the Public Officers Ethics Act and Leadership and Integrity Act.
And for the judiciary?
The Judicial Service Commission Act. Plus the Code of Conduct. The Judicial Code of Conduct, yeah.
Thank you. Okay, my next question. You said you are a member. No, before I go to that, you are aware that we have some 40 judges in waiting out there. And there is this, for lack of a better word, I'll call a stalemate that we have. The 40 judges were nominated by this commission almost a year ago. They've litigated, they've tried everything, and so far they have not been appointed and sworn into office. When you come into office as a Chief Justice, that will be one of the earliest problems or situations that you'll be confronted with. Have you given some thought to what you would do if you get appointed as a Chief Justice?
Yes, Honorable Commissioner, I have given this extensive thought, and my thoughts are in two ways. One, short term, two, long term. In the short term, I would want us to engage with the executive office of the President in a structured way, so through either the Committee on Governance or an ad hoc committee specifically for that purpose. Let's talk to each other, let's listen to each other, let's see what we can do, and we unravel that one. But then again, Honorable Commissioner, I would not want to see a situation like that repeat itself again, maybe 10 years from now, 15 years from now. And this is why, in what Commissioner Jir was talking about philosophy, I want the judiciary to be owned by the people. I want the people to feel it is their judiciary. So much so that if we cannot have a court of appeal running in Kisumu, let the people of Kisumu be the ones putting pressure to ensure that that court is operational. If we are short of staff and the court in Kwale is not running, let the people of Kwale help us in putting pressure. I would want this to be people driven so that we are not at the mercy of one person. It's very, very dangerous. I would want that one person also to receive pressure, get pressure from the people. The judiciary is for the people. So, in my approach, short-term diplomacy, long-term engage other people who are likely to support the judiciary should it ever come under siege in the future, in terms of funding, in terms of disobedience of court orders, or in any other form.
Thank you very much, Prof. My other question touches on the issue of security for judicial officers. I think it's a given that anyone who is discharging judicial function, or for that matter, judicial officer, needs security. Now, God willing, you'll soon be the head of this institution, and the welfare concerns of the people who will be serving under you will become your business. So you said earlier when you were beginning in your introductory remarks that you are a problem solver. If I remember your words correctly, you said, give me any problem and I'll solve it. So there's a problem here. We have judicial officers numbering slightly over 500 who discharge judicial functions, deal with cases involving dangerous criminals, cases involving high-stake corruption and all that, but they have absolutely no security. The latest communication that this commission got on that matter, in the latest communication, the SRC basically is directing the commission to liaise with the Inspector General of Police over the matter of security for judicial officers. You and I know that the police do not have that capacity to provide security for 500 judicial officers. In fact, as it were, they don't even have capacity to give them security when they're in court. The orderlies you see in court are never security for the magistrates. They're there for the remand prisoners. So, if you come on board as Chief Justice, how do you propose to solve this problem?
Thank you, Honorable Commissioner. Indeed, I did say I'm a problem solver. I love problems because they keep me busy and active. So, to the specific one. I would want to engage, firstly, through the National Council on the Administration of Justice. Try to get some understanding around there so that there is buy-in in the principle of providing security to all those judicial officers. The number will be increasing with time, but at least buy-in. Once there is buy-in, the next thing is to engage, say, with the other with the security apparatus. When I say that, I mean the IG's office. We also have KWS. We also have the prisons department. These three have officers trained in matters security. After engaging them, it becomes a question of working out modalities. Otherwise, Honorable Commissioner, I really sympathize with our judicial officers who, when they go shopping, they bump into somebody they sentenced a few years back, and they do not know what is in the mind of that person. We need to protect our security officers. I would want to use that kind of approach to arrive at a working solution.
Thank you, Professor. Now, my next question touches on your role at the Anti-Doping Agency. You're a member of the board of the Anti-Doping Agency?
Yeah.
Yes, you are. Okay, there are some recent amendments that were done to the Anti-Doping Act, specifically in Section 31A, subsection 1. Could you just please share with us what the amendment was about?
Yeah, now, first of all, let me say that I'm a member of the board. The agency is fully fledged and running. It has a very active legal department. Having said so, I did participate in some meetings where those amendments were approved. There were several amendments, but I think the one that the Honorable Commissioner may be having in mind is one that creates some in-house dispute resolution mechanism. And the intention here, which was also informed by the experience, allow me to go back in 1 minute. In 1996, when the agency was created, jurisdiction was given to the Sports Disputes Tribunal, which had been created earlier in another statute in 2012. Come 2018, the number of cases, very many of our athletes were caught doping, and the number of disputes getting to the Sports Disputes Tribunal were quite a lot. The members of the tribunal kind of complained about the workload they were experiencing. Coupled with that, the judiciary was not releasing their payments on time. So there was even a time they went on a go slow. As they were doing that, the international body was saying, you Kenyans, you are doping. We caught your athlete tested positive in Amsterdam, in Cape Town, where, you have done nothing about that. And here they are, want due process to take place. The matters are piled up at the Sports Disputes Tribunal. We did engage the Sports Disputes Tribunal, and they told us, look, so we are supposed to be paid this much. The judiciary has not paid us. We are unable to process any disputes. We even thought of engaging the judiciary through the Ministry of Sports to see how to resolve that stalemate. But then the cases were piling up, that backlog. And the international community is saying, if you are unable to handle those things, then we'll take them over. Taking them over means subjecting very many Kenyans to travel costs outside of the country. So then we also discussed with management, did discuss with the World Anti-Doping Agency, and there was an agreement on having some kind of in-house dispute resolution mechanism that would be fast, expeditious, and professional. So then that amendment was brought about to have the first instance hearings through the disciplinary committee of the Anti-Doping Agency, Then from there, appeals can go to the Sports Disputes Tribunal for national athletes and to the Court of Arbitration for Sport for international athletes.
Okay, just explain to us the structure of this body that the amendment created. It's a body that works under the agency.
Sorry, Commissioner, which board?
The body that has been, you've not given us the name of that body introduced by Section 31A. Yes, the disciplinary committee.
Yes.
It works under the agency.
The disciplinary committee more or less works under the agency, but the membership is drawn from outside. I'm not remembering everything, but the proposal was to have 3 advocates nominated by LSK and some 2 other people nominated by sports bodies, so that they are able to act fairly independently. The only interdependence would be number 1, in the payment of allowances, and number 2, the secretariat for processing, or the registry for processing the disputes.
You didn't see like this body, the whole scenario created by this amendment that apparently you pushed for would create an untidy scenario, given that you have a disciplinary body that is working under you, disciplining sports people who you essentially, in quotes, prosecute.
Now, Honorable Commissioner, there's something that we need to understand about resolution of sports disputes. It is customary that each sport body has an internal dispute resolution mechanism. The emphasis is that that body must be able to act independently. That is, I think that's the key thing. I talked about having served the Kenyan Premier League for about 6 years. This was formed by the football clubs. They used to pay our allowance, but they never interfered with our decisional independence. And this is why we served them fairly well. In terms of that section 31, let us first of all remove this feeling that I pushed. Honorable Commissioner, I drafted the 2016 Anti-Doping Act. At that time, it was very clear in my mind, I wanted a disciplinary body outside of the agency. And that's why we gave jurisdiction to the Sports Disputes Tribunal. Now, having used that for a while, management started experiencing those challenges of delays and threats from the international sphere. So, and that's why now this amendment came in. So first of all, I'm not the one who pushed for it. Crucify me for anything amiss in the 2016 Act, but not for the amendments.
The amendment wasn't pushed by the board that you are a member of.
The amendments were not pushed by the board, Honorable Commissioner. The board is advisory. We meet 4 times in a year. We leave management to do their thing in line with the provisions of Mwongozo.
Okay, thank you. Do we have the anti-doping regulations in place?
Honorable Commissioner, I did the ones of 2016.
Which were repealed?
They were not repealed. They are supposed to be amended, and this is because we have a new World Anti-Doping Code that took effect from January 2021. So those regulations are supposed to be amended to conform to the changes in the World Anti-Doping Code. Now, management was working on them. Where they have reached, I do not know.
Okay, thank you. On the application that you filed, I went through your documents. I was curious. I noticed you filled your form JSC2 by typing, yet the instructions said it should be handwritten. Did you have a problem with having it handwritten?
Honorable Commissioner, I don't have a problem with handwriting. I just thought we are in a digitized world, so I just
You just chose to be
I
different.
just typed in.
You chose to be different. Okay, I have a question for you. Do you consider money an asset?
I think it is, yes.
Money is an asset.
Yes.
And you understand the reason why we require you to fill wealth declaration forms?
Yes, I do.
Are you a public servant?
I teach in a private institution.
So you are not a public servant?
I would not define myself so.
Okay, thank you. So I noticed you did not disclose any money you may have in any bank account in your declaration. Is there any particular reason why? Now that you accept it is an asset?
Honorable Commissioner, initially it was so, but I have done so.
You submitted an updated one?
An addendum.
You have?
I have submitted.
Okay,
yes.
sorry about that. I think it has not been brought to my attention. At least at the time I was looking at your documents.
And Honorable Commissioner, while we are at that, and this is the JSC, could that form be amended to specifically or even give an emphasis on bank accounts and so on, so that for the avoidance of doubt?
The recommendation is noted.
Thank you.
We looked at your documents. I think I have not been able to pick anything else amiss. You've been cleared by the necessary authorities. The only issue that I had was about the wealth declaration. Maybe to conclude, I would like to ask you, Professor Dr. Moni Wekesa, if you are successful in becoming Chief Justice, many other titles will be added to your name. Would you consider sparing us the mouthful, Doctor? Should we add to your name, my Lord, the Chief Justice and President of the Supreme Court and Chair of the Judicial Service Commission?
I'm not particularly keen on titles. However, in academic circles, titles are everything. And this is why it's good to know whether somebody is a doctor or not, somebody is a professor or not, somebody has so many doctorates and so on. That is what we live on in academia. For the other sectors, even when I'm working with colleagues in other fora, they call me Moni, and I'm comfortable and at home with it. It doesn't injure me, it doesn't harm me. In my village, some people call me Professor, others call me Moni. I'm at home with anything. So I'm not particularly crazy about titles.
Thank you. At least that will free us somewhat to call you Chief Justice Moni and not to burden us with so many titles. Otherwise, I don't have any more questions. I wish you well, Professor.
Thank you, Honorable Commissioner.
Thank you, Chair.
Thank you very much, Commissioner Rwande. Professor, that is the end of our interview today. And we want to thank you for availing yourself. We want to thank you for answering questions very, very exhaustively. And we wish you all the best, Professor. Do you have any questions for the Commissioner or anything you want to tell us?
Honorable Chair, mine is also to thank you for your patience in this exercise. You are sitting very long hours, humanly speaking. It gets on the body. I just want to recommend that when you finish your business from here, please look for an indoor swimming pool, get somewhere where you can exercise to improve your blood circulation. Thank you, Honorable Chair.
Thank you very much, Professor. And the commissioners will decide whether to do that or not. But thank you very much. And on behalf of the commissioners, I wish you well, Professor, and have a good afternoon.